I recall him falling asleep on occasion, either at work or in the car. But here's the thing, though. The touchstone.
We're going to get started.
Good morning, Mr. Chairman.
All right. Well, why don't we start off with a word of prayer this morning and ask God's wisdom on this. Father, thank you so much for this day and the beauty of it. Thank you for the opportunities of the day. We've come before you now and ask you to quiet our hearts and give our minds the attentiveness that we need to have to the business of the state here as we work through these issues of the DUI opportunities that we face to make changes and to enhance our ability to manage through the situations we find ourselves in with the various aspects of this study committee. Thank you for all the members. I just thank you for the blessing of all those who have traveled here and the traveling mercies you've given them. I pray this is your wisdom and not ours in this meeting. Thank you in Jesus' name. Amen. Amen. I don't think anybody needs a introduction here, except that this time we have been joined by sort of ex officio Chairman Golick over there. Good morning, Rich. Good to see you. And Chairman Powell, thank you for coming. I'll tell you what, we got the whole power structure here of the Public Safety and Judiciary Committee. This is I feel, boy, this is really tough. So I thank you all for coming this morning, and I think everybody knows each other pretty much, and I think I've seen these faces around in various places, whether it's in my committee or in judiciary or in public safety or whatever, and so you guys have been gracious to come down today, and we thank you. We're going to start off this morning just with a couple of the numbers, and I've asked Mike Mitchell from the Department of Driver Services to come over, and he's got some charts that are just showing what DDS has experienced in terms of the historic issue of DUI and the licensing issue. So, Michael, why don't you go ahead?
Absolutely. Thank you, Mr. Chairman. Good morning, everyone. Appreciate being part of the discussions this morning. So if you recall from the initial meeting that we had September 9th, there was a good bit of discussion about the numbers of convictions, the number of ALS suspensions, refusals, et cetera. So I went back to our folks at headquarters and asked our good folks in our IT division to pull some numbers for me. And unfortunately, it probably doesn't show up that well on the screen down there, but did want to share with you the first slide here is the number of convictions that the department processed since 2007, since calendar year 2007. And what I did is I not only broke it down by year, but I also broke it down by whether or not the DUI conviction was a first, second, or third within a 5-year period. So I think Mr. Dallas in the kickoff meeting alluded to the fact that for the past several years, the total number of DUI convictions that have been processed by driver services has certainly been trending downward, and that certainly is verified by the numbers that I have from our folks at headquarters. So for calendar year 2013 in particular, the total number of DUI convictions that DDS processed was a little over 32,500. And overwhelmingly out of that number, the majority were first DUI convictions, roughly 85%. And so I went back and I looked at the comparison of first convictions to the overall total for the last several years, and consistently the number of first convictions account for about 85% of the DUI convictions that we process. And I say first and five because the way we treat DUIs in relation to the to driving privileges, we use a 5-year window. So essentially, if someone has a DUI and they get another one 6 years later, that's going to go back to a first and five. So that's how we treat it. The next slide here is the number of administrative driver's license suspensions that we process at Driver Services. This one is pretty much consistent across the board since calendar year 2007. Haven't seen a whole lot of fluctuation. So just for calendar year 2013, for example, we processed a total of 11,391 ALSs. And similar to the DUI convictions, the first ALS accounts for most of the ALSs that we process, roughly 95, 96%. And then the next slide we have is just a holistic view of ALSs, and I've got refusals added in here on this one, as well as ALSs. So you can definitely see just a holistic view of the number of convictions that we process compared to ALSs and refusals. One thing that I will mention about an ALS suspension is not every DUI case here in Georgia is going to be coupled with an ALS. The only time an ALS is issued is if it is a per se DUI, meaning that the blood alcohol concentration exceeded a certain threshold. So for adults here in Georgia, that per se threshold is 0.08. So those would be the cases that you would see the ALS issued. Officers make a lot of less safe cases, and in less safe DUI cases, you would not necessarily see an ALS suspension coupled with that. So that could probably explain some of the disparity between the number of ALSs and the number of DUI convictions that we process. And then last, wanted to take a look at the number of limited permits that we issue for folks that have been convicted of a DUI. Anyone here in Georgia that is licensed here in Georgia, they can apply for and obtain a limited driving permit on their first DUI conviction immediately after they walk out of the courtroom. They can come to us, and assuming that they did not refuse the implied consent and have nothing else on their record, they can qualify for the DUI first permit. So this is a breakdown of the number of those permits that we have issued, the first DUI permits, that's indicated by the blue bars. So in 2013, for example, we issued 18,214 limited permit to first offenders. And then the red bars are the interlock permits that we have issued. So for 2013, the number of interlock permits that we've issued is just a little over 3,600. And that is pretty consistent with some of the numbers that we have seen. There was a report that was issued within the past couple of weeks by Dr. Richard Roth that queried and surveyed the vendors here in Georgia as well as other states of the United States. And here in Georgia, the estimate is about, at any given time, there's probably about 3,600 folks here that has the interlock device installed on their vehicles. So those are the numbers. I hope that it will provide some context to some of the stuff that we will talk about today and some of the stuff that we've discussed, but I will be more than happy to entertain any questions that anyone has about the numbers or any other questions related to DUI suspensions.
Other questions from the committee for Mr. Mitchell? I got a couple. I'm just looking at the only time that they're going to get. I mean, on a second conviction, the interlock is mandatory, right?
That's correct. Yes, sir.
So when you say that the DUI interlock permits issued in 2013 were 3,618, and if I go back to 2013 and look at the suspensions processed, second offense, well, I guess that really doesn't tell you. Well, it's 479. Am I reading that right, or is it? Well, this is okay, DUI convictions processed by DDS on a second in 2013 were 4,963.
Correct.
Okay. All right. So that means, if I read this right, that means that there are about 1,000 people did not get an interlock device. A little more than 1,000 people, about 1,300 people didn't get an interlock device on a second. Is that?
That's correct.
Okay.
That's correct.
And the reason for that is they just chose.
I would
drive,
imagine there would be a subset of that group that would just probably gamble and continue driving suspended and not comply with the interlock requirement. Obviously, because the interlock is a condition of reinstatement, you know, if the person chooses not to have the device installed in the vehicle, in essence, they'll never be able to
They'll not
reinstate.
be able to drive, right. Okay, all right. I have a question from Representative Quick.
Thank you, Mr. Chairman, and thank you for your presentation. Can you tell me whether or not the ignition interlock is mandatory on a second if it is for drugs and not alcohol?
It would be, yes. The interlock is driven by convictions under 40-6-391. So a DUI drugs falls under the 40-6-391. So yes, it would be a DUI drugs would fall into.
Thank you.
Okay. Now, for the members of the committee, the follow-up slides that are available are covered in this handout from DDS that goes through the whole process in terms of what happens when there is a suspension and how the law applies to that in terms of the forms that are issued and what a person that's undergoing this process is looking at, right, in terms of the suspension periods and
Yes,
things
sir.
like that.
And I'll be happy to gloss over
Does
those.
anybody have a desire to work through that, or is this, are we fine? I think we've all been exposed to this at one point in time or another, hopefully. Is there a desire to have Mr. Mitchell go through this? If there is, we'll do it. We'll take the time to do it.
It's about
I think it's pretty self-explanatory, too, and I think some of us had a little bit of this when Jennifer presented this 2 years ago, I think it was, at that study committee, so Title 40 study committee. Well, there are no more questions that I see, and thank you, Mike, for coming today. I appreciate that.
Appreciate it.
You've
Thank you, sir.
done a good job with that. These are not easy things to get hold of, and I appreciate the time you all put into it in the department. We're going to move ahead, and what we're attempting to do today is to kind of make this a roundtable discussion a little bit, and not just have presentations, but let's have a fair amount of interaction on what's being proposed in other areas and how that might dovetail with what we're doing. We on the committee at the end of the last meeting had some opportunity to discuss the issue that we're looking at. And there are three basic issues that we're looking to make more efficient. We're talking about the first-time offense, and we're looking at the ability to dovetail mandatory interlock with this new ALS reform proposal that the Prosecuting Attorney's Council has and others have put together. We wanted to give credit for time served on an interlock before a case is adjudicated. We wanted to look at an interlock limited driving permit, not to restrict the driving privileges or destination. In other words, they can go anywhere if they've got that interlock on. Second issue was masking. There was a lot of interest in how do you keep first-time offenders from bearing that brand forever. And whether there's any other methods by which we can do that. And I think we've got some reports on that that are from another source here today, which we'll listen to. And then the third issue was cost savings. You know, how do you make it less expensive to go through the DUI issue, whether it's on the reinstatements and the licensing, or whether it's on the court costs, or whether it's probation, or whatever the issue is. There's a lot of ingredients to the cost of dealing with a DUI in one's life, and so those are the three areas that we're looking for more information on from you August gentlemen, and I guess it's October gentlemen right now, so that's a little bit better. Why don't you, Chuck? Why don't you start off? Just introduce yourself for everybody, and then we'll just go down the line.
Sure. Thank you, Mr. Chairman. I'm Chuck Spahas. I'm the Executive Director of the Prosecuting Attorney's Council. I've also served as an alleged Solicitor General for 10.5 years, so I've spent a good bit of time around these issues, and I'm glad to be here today and answer any questions and participate in the conversation.
Thank you. Judge?
My name is Kent Lawrence, and I'm a senior judge. I served as the state judicial outreach liaison for the state of Georgia. Worked through the governor's office of highway safety.
Okay, all right.
Good morning, Mr.
Good
Chairman.
morning,
My name is Jim
Judge.
Anderson. I'm the immediate past president of the Council of Municipal Court Judges. Judge Lanier, our current president, asked me to be here today.
Okay.
I was Sandy Springs Municipal Court Judge for 8.5 years until just this June. I continue to be a magistrate court judge in Fulton County, and I am a Norcross Municipal Court Judge as well.
Oh, okay.
That saved me.
That's part of my district, by the way.
They made me do that so that I could continue to work with the council.
Well, that's good. It's good to have you here with us, Jim. Thanks. So, it's interesting. I think that, these faces are getting incredibly familiar to me. I mean, dealing with 671 last year and, other things before. And then, Mr. Dallas, why don't you just...
Thank you, Mr. Chairman. My name is Bob Dallas, and for 8 years I served as the state's governor, the director of the Governor's Office of Highway Safety under the Perdue administration. And since 1990, I've been involved with highway safety issues here at the legislature with nonprofits, an attorney by trade, and remain very active in the transportation arena, but particularly representing the ignition interlock industry with respect to applying the best practices that other states have seen work to reduce crash deaths on the road.
Okay. All right. Well, thank you for coming. Thank you all for taking time. Mike, I see you joined them up front there. Thank you for all for coming today and contributing. I see Chairman Golick's got a comment or question. I'm sorry, it's a technical challenge down at that end of the table. Okay, well, why don't we do it this way? There has been an effort. Colonel and I have talked about the effort that was going on in public safety to look at the whole ALS procedure, which is what his major concern has been in terms of the resources that it takes to manage that whole process and the cost thereof in doing so. And he is working. We was working independently with Prosecuting Attorney's Counsel and others, and the DDS and others. I guess public safety too, and to obviously to come up with some ideas on this. And you formulated a proposal which, for the committee members, is found in your brief for today, and you can refer to that. Chuck, I assume you want to go through this and kind of. It's a formative type of thing. It's a work in process. It's not a completed.
Yes, Mr. Chairman, it is. I mean, we're prepared. I have with me today two individuals, Todd Hayes, who is the traffic resource prosecutor for the state of Georgia,
right.
Who is definitely our state guru, and then also Matt Kroll, the Solicitor General from Douglas County. We can go into as much detail, or we can obviously we've provided a great deal of detail in the presentation and the handout that's in your material. What this has been is it's been a working group, quite frankly, of the agencies and the heads, and Colonel McDonough did start the process, and we've come together and looked at the ALS process as a whole. I will say we've made some observations about, and I think your numbers showed a little bit of that, of why there is a discrepancy or disparity in number of DUIs versus the number that have administrative license suspensions, particularly the ones that start prior to the conviction, is that process is antiquated. It is, in our opinion, a process that is often abused. There's these officers they have to fill out the forms, turn them in, start that process, and then generally attend these hearings on their own, fend for themselves in front of an administrative law judge, often with a defendant that's represented by counsel, and that process in and of itself tends to get a little off track, and it's become kind of an unspoken truth in the law enforcement community that the value of starting that process is not as high as it once was from a law enforcement standpoint. I think that it's become a little more commonplace to say we'll let driver services and ALS and the courts figure it all out after the conviction. Mm-hmm. And so the process doesn't work the way it was obviously intended in the beginning. That being said, we've got some proposals that we can hit high level, or like I said, they're there in that handout. I don't think anybody.
Well, I think I've gone through the handout. I think it's good. It's kind of a net view. Todd, but you've got a presentation on what what the details of this are a little bit. I think we'd like to know more about that. We spent some time on ALS last time. And
Okay. Well,
we'll try
to hit the high points and roll through it, Mr. Hayes.
I will do that as expeditiously as I can. Thank you. Mr. Chairman, my name is Todd Hayes, and I am the Traffic Safety Resource Prosecutor, as Mr. Spahos indicated, and I very much appreciate the opportunity to present this information. This is kind of the collective thought process of a bunch of different agencies, and I kind of got the job of putting it down into a working document, and these are the points we came up with as it relates to implied consent and administrative license suspension reform. First of all, we think it will fall in line with the recent trend in criminal justice reform to try to improve and reduce recidivism, and that it kind of dovetails in with that. First of all, we would recommend and have thought about eliminating license suspensions for anything that does not relate to a moving violation. That includes things like failure to pay child support and simple drug possession that is not related to a traffic offense. After speaking with the Department of Driver Services, we are told that that would be a significant cost savings and a significant enforcement savings on them. Next, we would recommend that the entire process only apply to those individuals who refuse. In other words, it not be tied to any offenders who actually go along with and take the state test. Currently, it's structured so that if you refuse or are over a limit tied to either your age or your type of license, you can also be suspended. In order to encourage compliance, we would simply recommend that we take it down to a process that only applies to those who refuse and eliminate the other part of that. Next, we would provide that those who simply do not request a hearing within 10 days would be suspended by operation of law within 10 days as it currently happens. However, they would be able to immediately apply for and obtain an ignition interlock permit, which would allow them to continue driving. However, depending on their DUI history, the length of time that they must have that interlocked on would be tiered. We have not discussed in any great detail what the nature of those tiers would be, but it does seem to make sense to tier that to a history. Next, we would provide that, and we try to do this in statute already, but I think we can tailor it a bit more narrowly. When they do request a hearing, we would suggest limiting the hearing to whether or not there was a sufficient warning and whether or not there was a refusal. So the only things we would be talking about at administrative license hearings would be, was there a reason to stop the offender? Was there probable cause to arrest the offender? Was the implied consent warning timely, or if not timely, were there exigencies? Was it sufficient? In other words, was it read correctly from the card? Was it the correct warning based on age and type of vehicle? And again, did the offender comply or refuse? Those would be the only issues that we would cover at an implied consent hearing. Next, we would provide that if the offender requests a hearing and the suspension is upheld by the administrative law judge, essentially the penalties would be the same. They would be suspended. They would immediately be able to apply for an ignition interlock permit, and again, the length of that time would be tiered based upon their prior history. We would suggest that those offenders who are required to get that ignition interlock permit but who comply, and that's whether or not they request a hearing or not, as long as they are compliant with the terms of that ignition interlock permit, any time that's credited toward that administrative suspension would also credit to the post-conviction suspension, as long as there is no violation with the terms of that permit. However, if you do violate the terms of that permit, you could be prosecuted for a separate criminal offense. And as a part of that separate criminal prosecution, we would provide that that offense would not merge into any other offense. In other words, it's a separate offense entirely and doesn't fall down into any other category. It would disallow that post-conviction credit that you would otherwise be allowed to have. In other words, you would actually have to go through it twice instead of being allowed to have that credit. And the punishment would be based in pretty much the same way we already punish suspended license offenses under OCGA 40-5-121, and that is a tiered process based on your suspension history. We would also suggest that the administrative penalty handed down through that process not be affected if the offender enters a guilty plea other than to a DUI or is acquitted in the criminal case. Currently, if you have someone who refuses and they go through the process and they are acquitted, that suspension is taken off. Well, that really doesn't address the issue, and the issue is voluntary compliance with the implied consent warning. So if the administrative process is put on an entirely separate track that is independent from the criminal process, it tends to improve that sort of voluntary compliance. And that's just explained a little more right there. And then I believe this is the final point. We would suggest that as a part of this, law enforcement officers not be able to enter into joint withdrawal agreements. Currently, when you go to an ALS hearing, and this has become a great deal more powerful recently under a recent case from our Court of Appeals called Flading versus the state, the defense attorney and the law enforcement officer, or the defendant if he's not represented, can't enter into an agreement whereby the officer withdraws the petition to suspend in exchange for the defendant's agreement to enter a guilty plea at arraignment. And the Flading case says that those agreements, if the verbiage is correct and the withdrawal, can actually be introduced as essentially an admission of guilt at the criminal trial. There has been some concern over the years that perhaps the position we're putting our law enforcement officers in is the position that they are being forced under the statute to engage in the unauthorized practice of law. Are they actually being required to represent the department on their own, and are they empowered to do that? So our thought is if we can just get them out of that process and either there's a hearing or not and don't allow them to engage in those type of negotiations, again, it keeps the two systems independent and separate as was intended at the outset. And that's kind of where we stand on the suggestions as it relates to administrative license and implied consent provisions. And I'll be happy to field any questions if there are any.
Questions from the committee? All right. Chairman Golick.
Thank you, Mr. Chairman. And I do appreciate the invitation to join you this morning. I appreciate the work. I think that's a very balanced piece of work product that you put forward for the study committee in specific and the General Assembly to consider. I think it does reflect the reality that it does put the law enforcement officer in an awkward position, may be the right word, because they're literally, they're negotiating. I mean, everything you talk to practitioners, both on the defense side and then also those assistant solicitors, both at the county and municipal levels, and, you know, the inevitable story is, yeah, I'll go ahead and, you know, you can go ahead and we'll lift the suspension, but you got a plea. I mean, is that the appropriate role of the law enforcement officer at all? Do they even want to be in that role? I doubt it. And then what does that really say for the integrity of the system in terms of, is this the best thing for public safety? Yes or no? Or are they just trying to move paper? And they're very, I mean, don't get me wrong, they've got more than enough to do than to deal with this type of thing, and I think we're all aware of that. So I just wanted to wrap that by just acknowledging the clearly well thought out work product on that. This is a process reform issue as far as I see it that will go ahead and enhance public safety, you know, in the long term. How interlock plays into that, I think, is a sort of a to be determined factor in the conversation. One other question I had for you in terms of the process, and it's not about the ALS process, but while you're up there, I know that several jurisdictions over the course of, and I mean several, perhaps just a few, over the course of several years have gotten some attention in the media over situations where we've had a refusal and the individual citizens who have refused have been, apparently warrants have been executed and they have been detained, put into custody, strapped down, and a blood sample has been drawn. I guess my question to you is, if we have, and the law does not prohibit that at this time. My understanding, having looked at it many months ago, but not recently, is that there's no express permissive language in the code allowing for that, but there's no prohibition, that some jurisdictions have engaged in that. And then once, of course, some attention came to that particular practice, those jurisdictions suspended that practice. I understand, secondhand, very secondhand. If we have a situation, you know, beyond just the disturbing visual of a citizen being strapped down and a blood sample forcibly taken, just from a process standpoint, going back to your presentation, doesn't that process, as disturbing as it is, putting that aside, doesn't that really render a refusal a fiction under our current law?
I think I can give you a two-part answer to that, and,
okay.
And I'll answer the second part first, because that's the question you actually asked, and is, does it make a refusal a fiction? The answer is no. There are two separate processes here, and it's very important that we consider them side by side, but separately. The first process is the implied consent administrative license suspension process that is statutory, that you all have created. The second one is the Fourth Amendment jurisprudence that is a product of Georgia case law and federal case law, and they They do run parallel. They don't ever really intersect. So the search warrant issue is a Fourth Amendment issue. And we kind of take the constitutional Fourth Amendment issues as our floor. And anything we build, we put on top of that floor. So from a legal standpoint, the implied consent system and the administrative license system sits on top of the Fourth Amendment, which means we kind of depend on the existence of those warrants as a basis for implied consent. And here's what I mean. If you look back historically, the very seminal case on this is Schmerber versus California, which is out of California in the late 60s. That was a case where a warrantless search, well, basically a warrantless draw was forced on this citizen of California based on exigent circumstances. And the Supreme Court of the United States looked at that and said, well, that's fine. If you've got exigent circumstances, you can do a warrantless blood draw. And that practice started becoming more and more common. And legislatures like you looked at that and said, well, we don't really want that. That's not so much what we intend. We certainly don't want armed conflict between a citizen and law enforcement when that law enforcement says, hey, I've got an exigency and I'm taking your blood. So we built the implied consent administrative process on top of that. So we kind of assume the existence of that. Now, what happened in Georgia was the terminology that got into our administrative licensing statute and our implied consent statute had the language that no test shall be given. Nobody really ever thought about that until a Collier case came out in 2006, and that was a product of a vehicular homicide case in the Coweta Circuit where there was a blood draw that was based on a warrant, and that got reviewed all the way up. And what came out of the Collier case was that no, the language in implied consent provides additional protection above and beyond what the Fourth Amendment would protect. And for a time there, we changed paradigms a bit into a world where you could not get a search warrant. And in the following legislative session, this body acted and put 40-5-67.1D.1 in, which restored us to what we all thought was going on anyway, which is you can, via voluntary consent or a warrant, continue to get that evidence. So my answer to it is no, it doesn't really make it a fiction, because what our Supreme Court in a case called McAllister said recently, and I think it was January of this year, our Supreme Court said, look, the language that refers to no test shall be given refers to a warrantless search. In other words, if a citizen says, no, I am not taking that test, the state cannot go forward until we present an independent and detached magistrate with facts that establish probable cause to believe that that person has committed an offense and that the evidence of that offense is flowing through their bloodstream. So until we go forward and take that step, no test shall be given. However, says the Supreme Court, under D.1, if you take that step and if you get that warrant, then you can go forward and get the evidence. So that's why I say no, it doesn't make it a fiction, because you're talking about two separate tracks.
Can I follow up on that, Mr. Chairman?
Follow up, sure.
All right, so let's just play that out, just from a real-world standpoint.
Sure.
The stop is made. Just walk us through it, I guess, is what I'm asking you. I mean, you know, there's a roadblock. Individual refuses. They're clearly inebriated to some degree. The officer has probable cause. Let's just say that's solid as a rock. Take us through the chain of events at that point that's going to, I don't want to use the word validate because I think that's an improper word, but what's going to get to the point where that individual is strapped down and there's an involuntary, on their part, blood draw? What's the chain of events? How does it really work?
And this is where I need to give you the other answer that talks about the strap down, because this is kind of a fiction that's been perpetuated, and I want to get to that. The chain of events is once the officer in his mind has developed probable cause to effectuate arrest, he will put that offender under arrest. He will read the implied consent warning. At that point, the offender under your scenario would have to say no, because if they say yes, obviously we're going down a different track. Mm-hmm. So they refuse to take the test. At that point, the officer will put the person in the car and begin the booking process, and at the same time, they will begin the process of applying for a search warrant. That process is very different in different jurisdictions across the state, very different. There are places like Douglas County, like Gwinnett County, like City of Atlanta, where they've got that process down to around 45 minutes using some electronic technology, electronic warrant systems, video conferencing with the judge. Our statute does require that you see the judge, so even if you're doing it electronically, you're hooking up via something like Yahoo Chat, and you're looking at the judge, you're presenting your facts, you electronically submit your affidavit for the search warrant. The judge looks it over, asks any questions he would like. It's required that that warrant application be recorded, so you have to have that technology available as well. If the judge passes and says that there is in fact probable cause, he will electronically sign that document. He will turn the electronically signed document back around to the officer, and then the officer takes that document to the appropriate drawing person, whether that's a jail nurse. In the two jurisdictions that have this really down in an efficient sort of a way, it's a company called 108 Forensics that provides that service to the law enforcement agency for a fee. The blood is then drawn by a qualified person, and that blood draw kit is then sent to GBI for testing. So that's the way it works. Now let me address what you asked about being strapped down. Here's how that story came out of Fox 5. The Fox 5 story focused on Gwinnett County. And it focused on blood draws that were taking place at the jail in Gwinnett County. And just let me tell you how the Gwinnett County Police Department and Sheriff's Office interact, because you're dealing with two law enforcement agencies here. The agency that has the warrant protocol in place is the Gwinnett County Police Department. The agency that has the strap-down policy is the Gwinnett County Sheriff's Office. And the Sheriff's Office has the strap-down policy, or had the strap-down policy in place for anyone who needed a blood draw of any sort who was in their custody, because they wanted to avoid liability issues that dealt with prisoners who might be fighting or otherwise not being compliant or disruptive. And they had that policy as a blanket policy. It didn't make exceptions for anything. So anyone who came into the jail and needed a blood draw of any sort would be strapped down and have that blood drawn. Now here's how it interacts with the warrant issue. The policy of the Gwinnett County Police Department was, if you have to get a warrant, take that offender to either the nearest Gwinnett County Police Precinct or the jail to get a blood draw. Or if they are disruptive, then take them to the jail. Okay? So that was how it worked. So for the most part, it was simply a luck of where you got stopped as to where you went to have your blood drawn. And the majority of offenders were taken to the closest precinct. They were compliant, they were strapped into nothing, and the blood was taken. For a very few who were geographically closest to the jail, they did have to go through that process. And then anyone who was disruptive obviously would have to go through that process. So the numbers that you're talking about are actually a very small percentage, and Gwinnett's kept those numbers and actually have the database. If you need me to, I can run through and tell you exactly how many of those people were non-compliant and how many actually had to go through that process. But for the most part, it was either at that point in time last summer a pure function of geography and two policies that had not yet meshed. Those policies have since been redrawn to mesh so that if you have a compliant offender, even if they're taken to the jail, they're not being strapped down. But Gwinnett County never suspended their warrant program. They just modified how they went about it to take account of the fact that you had two different policies competing with each other. Does that answer your question? I know it's a long way.
Mr. Chairman, do you mind if I continue with this line of questioning?
That's fine.
Thank you. And I'll try to make this the final. I understand the separation between the ALS process and the Fourth Amendment. Those are two separate analyses. We get that. I don't think we've received an adequate answer on whether or not, I think we're talking about it in terms of with the refusal becoming a fiction. I think we're looking at it, the question really was more from a broader public policy standpoint. If you were to go out on the street or in the Publix over in Vinings, would people consider that to be a refusal, and should law enforcement be able to do that when it has other methods available and it has a suspension process available? That's not something for you necessarily to answer. It's something I think for us to go ahead and flesh through in the coming months. The real question is, the on-the-street question is, you've only had a few jurisdictions that have done this, and the vast majority, 40-something jurisdictions, I guess the 40-something circuits, believe 159 counties, have chosen to not employ that process. But a few have. What's your opinion as to why 100 and something jurisdictions have not employed that process?
Two reasons.
What is it about the process that they find that they're going to err on the side of not doing it?
I think there's two reasons, and I think they are. I think they speak powerfully to why this body should continue to allow the process to go forward. First of all, it is local choice. If the citizens of a particular jurisdiction choose not to employ this process, they're free not to, and that's fine. However, if other citizens choose to, they are free to, and that is also fine. That actually allows greater local choice in how law enforcement strategies are pursued. I've got some material prepared as to the effectiveness of those jurisdictions. The other reason I think is technology-based. There are simply some agencies and some jurisdictions in our state, and I have the great privilege of traveling all over our state, so I can tell you I've taught everywhere from GJAC in Lawrenceville, where I had a 190-seat auditorium and every bell and whistle you can get, all the way down to Lumber City in Telfair County, where they thumbtacked a horse blanket to the wall for the presentation. So it runs the gambit. So a lot of it is simply technology-based, that they don't have the time or the resources to invest in developing a system where they can turn that warrant around in 45 minutes. I can tell you that a lot of the places that I go, they are interested in the program and they are interested in beginning to look at how to implement it.
And it doesn't strike you as a possibility that the 100-something jurisdictions of this state don't employ a program like that because they understand that it offends the sensibility of the people that they are protecting? Does that ever enter the, I mean, does that enter the contemplation? The fact that citizens are strapped down and blood is taken from them involuntarily? Do you think that goes into their calculation as to whether or not they go ahead and employ that practice?
I wouldn't want to speak on behalf of other elected representatives that
Sure.
I'm not empowered to speak for, so I wouldn't dare speak for
It's a
them.
completely unfair question.
I-
But it is the absolutely operative question, isn't it? I
Well,
mean,
I-
it's the
I-
real world on the street. This is the real reason why it doesn't happen, because the idea of law enforcement strapping somebody down and taking their blood in this country rises to the level of offense, regardless of how pro-law enforcement you might be. And you got a lot of pro-law enforcement people at this table, I can promise you that.
I understand that.
But certain things just go beyond the pale. Don't you think that might have something to do with it?
Again, I'm not going to dare to speak for them. I do think when you look at the actual numbers in play, and I don't even want to speak for Mr. Spahos because he can speak for the council, but when you look at the actual facts, I think it does impact how you view the entire practice. And if you want to look at those numbers, I've got them for you, and I'm happy to provide them.
I appreciate your standing there and taking that, but I think it's an important point to make. And, Mr. Chairman, I appreciate the indulgence.
Mr. Chairman, do you mind if I comment on
I would enjoy that.
Thank you. My experience in this regard is as a judge, both as a municipal court judge and as a Fulton County magistrate, who has issued what we call blood warrants. Most of the blood warrants I've issued have been for the Georgia State Patrol, not for local law enforcement. And I'm not taking a pro-law enforcement stand here, but I want to tell you what I've heard. I've heard the frustration of the State Patrol trooper at 3 o'clock in the morning who's responded to an intersection collision at Piedmont and Peachtree where people are mangled on the street and being carried away in ambulances from an obviously drunk driver who is falling all over him or herself and won't comply with the implied consent. I see the frustration in the trooper's eyes. I see him, and refusal is a big deal for me personally as a judge. And I see the frustration in his eyes. I see the case I see him thinking, oh my God, if this guy doesn't blow into the intoxilizer or allow me to take his blood, then this case is going away. And these people are being carried away to Grady with their arms and legs broken and their lives disrupted forever. That's a problem. So there are two sides to this issue. Representative Golick, I hear what you're saying. The thought of strapping somebody down involuntarily and taking their bodily fluids, it just sounds awful. It does. The thought of somebody being hauled away in an ambulance with their limbs askew and asunder, their lives changed forever from a drunk driver, that's awful too. So we've got balancing acts here. And
Mr. Chairman, may I go ahead and ask a question in relation to that?
I kind of felt you might have a...
Well, let's just be clear, Judge. We're all very sensitive to that, and we have the plaques on the wall to prove it as well.
I know.
So, but I guess my question to you is, with the technology that we've been talking about right now, I mean, you've got the camera in the cruiser, You've got obviously the trooper's testimony. It's not just, I guess the operative question, one of the operative questions now is, you know, can't the case, I would hope the case, that person is as drunk as you say, and I'm sure they are, and I'm sure that officer is frustrated, but can't the case be made separate and apart from getting that blood sample because of the officer's testimony, because of the testimony of witnesses who saw the accident, because of the onboard video, and he goes through the, I forgot the term, but you know, when they go through the field sobriety tests, right, in front of and the camera's right there recording the whole thing. I mean, you're piling, you know, you're building these bricks for this case, and all of a sudden, when you've got all those components of testimony and the officer and the video, which doesn't lie, you're building a pretty strong wall. And so, if that's the case, especially in the scenario that you brought out as an example, it seems to me that's pretty strong, separate and apart, and therefore, would there be a need for that sample? I can foresee a circumstance where a sample like that would be necessary. I absolutely agree that I can foresee a circumstance, I can think of a scenario where that would be necessary, but wouldn't the vast majority of cases really be able to stand on their own without that? I mean, that's a really open-ended question that I'm seeking an answer for.
Certainly. The stronger the evidence that is available is available, the more likely there is to be a conviction. Now, I'm not here advocating for convictions. Let me make sure everybody understands that. But not every trooper's car or police officer's car has a camera. We don't all have cameras to record the field sobriety examinations, the field sobriety tests. Not every case has all those bricks that you were talking about. Eyewitness testimony is the most unreliable testimony we have in court. It's the most subject to cross-examination. It's the most subject to discredit. You get 6 people, everybody knows, and it's easily demonstrated in court that you're going to get 6 different versions of what happens. By the time the defendant appears in court, they're shined up, polished up, and looking pretty good. So are we going to take away this tool? Are we going to take away this brick? I'm not sure I'm going to advocate for that. I would certainly advocate for, but likewise, I would not advocate for strapping everybody down like Lynette apparently was doing for a while. But take away what the Supreme Court has said is a legitimate tool of law enforcement to do their job, I think would be in a selective group of cases. What's the next group of cases you're not going to let them take a blood sample on? I mean, this is subject to the Fourth Amendment, and like any other piece of evidence, if it stands on the Fourth Amendment, then, and I'll be honest with you, the thought of it, when I issued my first blood warrant, I wasn't thrilled either. It just didn't sound like the United States of America to me. But as a judge, if a police officer or a law enforcement officer submits to me probable cause, sufficient probable cause under oath, that a crime has been committed, that there is evidence now somewhere, either in a house, a car, or a person's body, that furnishes evidence of that crime, and my duty is to issue the warrant, whether I like it or not.
You've gotten, Judge, where I think we wanted to go, and that was limited circumstances. Not a blanket practice, certain limited circumstances. How you go ahead and define that, I don't know. But well, I mean, we had a situation where it was standard operating procedure, I understand, secondhand. But we also have those situations where you've just given an example of a great example where, gosh, maybe it's necessary, maybe. And so how do you go ahead and thread that needle? Thank you, Mr. Chairman.
To keep it out of the routine procedure, one available methodology would be the failed method that was tried a couple of years ago, where you got a blood sample or a breath sample for every fatality. That's unconstitutional because it's not necessarily not probable cause to believe a crime. But if you had all probable cause and there was serious injury or fatality, that would be one way you could get it out of the routine, and it would solve my problem. I don't want everybody that's arrested for DUI where the police officer gets a whiff of alcohol from the breath going down to the police department and getting involuntarily blood drawn. I don't want that as a citizen. Yeah. But if somebody's dead, somebody's seriously injured, am I going to take that tool away from the troopers or the officers? No, I wouldn't.
Mr. Chairman.
Sure, Chuck.
One comment, and Chairman Golick and I have participated in this debate over the last year or two, and there's, I truly see the point, and I think you've just made my point is we can all agree that, and I'll just use this as an example, in a sexual assault case where we have a defendant that is not cooperative but probable cause, and we know that DNA is going to prove intercourse took place, we all get that that's the kind of situation I think all of us can agree that a search warrant is appropriate, even if that means holding that individual down after that's been issued and taking that blood. What we're really talking about is what comfort level are we at on what kinds of cases are we going to use that kind of intrusive search. I mean, really, that's the end of the day. If we know we're going to do it in sexual assault cases, we're not comfortable doing it in every run-of-the-mill DUI, and somewhere in between is that balance. And I get that we've got to strike that. I would ask that we be given the opportunity to, and we've prepared that presentation today, so either today or at some later point, to at least look at the effectiveness of this tool from a law enforcement standpoint. We've got a presentation about the Douglas County project. We've got the solicitor here that's done that. And I think you should at least see that for twofold. First of all, the results that have come out of these testing. In other words, if you're concerned that, as the judge just said, every time we smell alcohol we can go get a judge sign a warrant and we can do intrusiveness, then you need to look at what we're actually finding when we do execute the search warrants and extract the blood and what the results have been. And they're not somebody that just smells of alcohol. They're significantly high blood alcohol counts. So to see that, and then to see the effect it has had on the case disposition in Douglas County. And I think it would not take long for us to go through that, and I think at least to intelligently have this conversation, we need to vet that set of facts as well.
Okay, thank you for your comments. I just want to remind the committee we've got a little ways to go here in terms of some other issues that have what I'd really like to do is to take a few more minutes on this particular issue. I know we've got some questions on that, and then I'd like to move to your proposal, and I'd like to take the slides point by point and just run through those to see if they generate some questions. And what I'm looking for here, and I think what the committee is looking for, is the mesh point of what this committee has already looked at in terms of a better way to manage the rehabilitation of DUI drivers via the use of interlock device or whatever other methodology is appropriate to help that. And there are a lot of them, obviously. So if we could go through that, and they're articulated pretty well here, and I've got some questions about some of the other points that you made in your presentation. But let's go ahead. I see 3 lights lit up here, and I assume that, I know we've been joined by Chairman Setzler, and I'm going to recognize you for a follow-up.
Thank you, Mr. Chairman. I'd like to kind of follow up on Chairman Golick's questions, and I think following the judge's point, I think when we look at this, when you think about the public interest in having a DUI law in the first place, it's to ensure that on public roads, intoxicated, impaired drivers aren't there to harm the public. And there's no law in Georgia that you can't drive on your driveway and on your farm intoxicated. It may be a bad practice, but there's not a law specifically against driving around a truck on your farm. It is what it is.
Well, it certainly gets enforced differently.
It's certainly a different context than driving on public roads. I mean, our interest on public roads is protection of the public. Okay, and that the idea of the implied consent law, taking people off the road without a license for a year, and however we reform that long period of time, whether it's under electronic surveillance via interlock or some other combination of things. I think we follow that the public interest in getting drunks off the road who've been caught driving drunk is protecting people, protecting other motorists and folks who are driving. Okay, And to the extent that public end can be satisfied, an implied consent law is arguably legally sufficient because they're getting off the road. You're taking them away from being able to harm the public in the future. Whether or not there's a subsequent conviction that's obtained or what the conviction looks like, one could argue that the conviction piece may be secondary to the protection of getting folks off the road who might be dangerous drivers in the future. The idea that they just slap them with a conviction versus getting them off the road. I think getting them off the road, you could argue, is in the highest public interest with respect to their ability to offend and harm others. I think the real essence of the forced blood draw, as distinct from someone being able to refuse and follow the implied consent rubric, is that if implied consent's granted, yeah, they lose their license, but what could arguably be the determinative evidence in a felony case that whether say there's a vehicular homicide, death occurs from the drunk driver. I mean, the whole case in a vehicular homicide case could turn on was the person drunk or not. For example, if there's someone driving down a divided 4-lane highway in Cobb County, a person steps out in a crosswalk. Who did they have right of way? Did they not? If the person was drunk, even if the driver could say it was a jaywalker, for example, or there was the facts of the case were such that if the person's driving the speed limit, otherwise driving legally, if they're not drunk, it might be the pedestrian's fault. But if they're found to be 0.2 BAC, had you not been 0.2 BAC, you could have avoided hitting them. And it really, I mean, a vehicular homicide case could hinge, as you know better than I do, on the blood alcohol content. So really, the whole case could hinge on were you drunk or were you not drunk. Not suspending them from having a license for a year, but really a felony case, a homicide case, could really hinge on were you 0.08 BAC or higher. It's those circumstances, as the judge introduces in the case of that serious injury there. When a case hinges, a felony case, hinges on the blood alcohol content, those are the circumstances in which I would submit the public begins to understand it makes sense if the person refuses, that they're strapped down, you get a warrant, you take the blood. Because it's not a matter of getting them off the road. Getting them off the road for a garden variety DUI is really the public's greatest interest. But in the case of a felony case, where the underlying felony hinges on establishing were they drunk or were they not drunk, those are the circumstances I think Chairman Golick's speaking to. So I think we follow the judge's reasoning that for garden variety DUIs, as it were, the greatest public interest is getting folks off the road, getting into a rehabilitation program, and those kinds of things. But when felony cases hinge on were they drunk or were they not drunk based on the facts of the case, that's where I think the legislature's invited to give discretion for that subset of cases for law enforcement to be able to do exactly what the judge has said.
The fallacy with that logic is you can't get to the suspension, the rehabilitation, all of the other things that you've discussed that the public's got an interest in on that offender without the conviction. And you can't get to the conviction when there's been a refusal of field sobrieties, a refusal of the state-administered test, but sufficient evidence to support probable cause. You don't get to all the other things that you're after without a conviction.
Perhaps under our current rubric. That's why, as we talk about ALS and implied consent reform, there's nothing that would stop this legislature from requiring someone that refuses to have to go through the rehabilitation, a whole series of things that would mirror what a conviction brings from a public protection perspective. There's nothing that would stop us from doing that.
No, but interestingly enough, and we go back enough years in judiciary hearings to know that when we proposed bills in the past to strengthen one before this became such a subject matter, that it becomes, well, we're going to add all these conditions to people without a conviction. Doesn't that violate due process and that kind of thing? So we've got to balance that.
I don't think it violates due process to say to enjoy the privilege of driving on public roads. You understand you're going to lose that privilege for a year if you're pulled over for DUI. There's probable cause and you refuse. And oh, by the way, you've got to go to classes and things like that. I think that's well within. I mean, you're not putting people on probation without probable cause, without a court hearing. You're not using punitive I mean, you're not caught up in a criminal context. It's still administrative in nature, what could be prescribed. I think the rubric around implied consent could be strengthened from a public safety perspective to get at the core, I think, essential issue that Chairman Golick raises is it appropriate, is it necessary, if we're able to get people off the road, get them into a rehabilitation program, a whole series of things we can do administratively. If that's possible for folks who refuse, why do we have to go get the evidence, which really ties back to more of a criminal conviction? The criminal conviction, I would argue, is essential if that is the case, if public safety and justice hinges on that. But the real public interest in a garden variety DUI case hinges more on public protection and rehabilitation more than it does on having that evidence on which hinges a much, much higher trial, whether it's a vehicular homicide or otherwise. And I think that's the wisdom of what the judge has said, and I think he invites us to act that way in this, Mr. Chairman, in this reform process.
I don't want to spend all day on on the particular issue that's been raised here. It's an important issue. I think Ms. Doherty has done some work on the issue of case law and things like this, and I'm sure the judges know how that all works now. And some of this issue, in terms of the standards, they've already been tried, I believe. And so what's due process, really?
But I would say, Mr. Chairman, just because the courts have said existing law allows this to happen, as lawmakers, as policymakers that represent 54,000 people back home, what should the policy of the state be? The court may give us a broader berth than the legislature is willing to recognize, and I think the direction we should follow is what's the appropriate balance.
Well, I think probably it would be a good idea if you guys, in your wisdom, could consider this issue a little more and come back with some proposals that would bear on the differences here and the structure by which we may go ahead and authorize this in law. There are a couple more questions, and the Representative Quick, you were next.
Mr. Chairman, I'll waive.
Waves. Okay, and then we have Chairman Powell.
Thank you, Mr. Chairman. What I understand that this proposal and existing law is to deal while things are winding their way through the court system on the criminal charge, is to get the dangerous guy off the road, suspend his license, perhaps under this proposal get him to, if he still needs to go to work or whatever it is, to have an interlock device. My question is, taking all of those things as givens, that those are all admirable goals, could we not, without putting in a separate administrative proceeding that is separate from the criminal proceeding, not do all of the same thing by making some requirements for release on bond that puts these things as bond conditions, and just do away with the whole administrative suspension process and just keep things on one track rather than doing two tracks and just tighten up our existing criminal proceedings?
Well, Mr. Chairman, I submit that the judge has the authority to put that as a condition of bond in these kind of cases now. I think you will get into a practical application issue with that of what do you do to the one that gets locked up at night? Does that mean he has to stay till in the morning until he can have it installed into his car, or what is that period of time? So there would be some procedural aspects of it. I'm not willing to die on this hill today over this argument, but I think Mr. Satchler makes a good point. We've got to significantly change the way we're doing one side of this before we can agree that there might need to be some changes on the search warrant side of it. And the other thing I do want to point out is I think we also got to look at what do we do, because I think we make a mistake when we start talking about DUIs in the concept of a run-of-the-mill DUI. Because I think it's real important to look at his numbers that say that 85% of the DUIs are first offense, which means a significant number of people that get the first run-of-the-mill DUI don't get another one because of all the things that we have done and imposed on that first-time offender in this state, and we don't need to forget that. But as far
Well,
as
to follow up on that point, what we also don't need to forget is the fact that the first offense is not the first offense.
That's correct.
It's the first time they've been caught.
Yes, sir.
They've been out there and endangering themselves and the public for a long time before they get caught.
Yes, sir, I agree. And but I think to answer your direct question, the more meat we can put into the administrative side of that process, and the quicker we can intervene in that offender's behavior, then the more likely we are to be willing to talk to.
Well, and I don't disagree with you, but I guess my question is that when we talk about streamlining and we talk about trying to make the process more efficient, what we're basically saying is that a judge has a lot of these tools available to them now and are not using them. So what we're doing is we're putting in another process because part of the process is not working now.
Yes, sir.
And so rather than have two processes, both of which, you know, are not necessarily working, is to have one process that works and works well. And I guess my question is, you know, should we not focus on trying to make one process work rather than putting on a second? And then if that doesn't work, then we put on a third, and we're just putting Band-Aids on there when we ought to be just fixing the underlying situation.
Yes.
Okay.
Why don't we do this? Judge, I know you've come, you got a presentation that you've done. I've heard you last year comment on what happens up in your jurisdiction. Yeah, yeah. Matt, yeah, I'm sorry, Matt.
That's okay. You call me judge, you're the chancellor's solicitor, but that's okay. I'm not a judge yet.
It's close enough. Maybe.
Yeah, right.
Thank you, Judge.
Since this is being recorded, you could look at this as kind of a, you know, a trial type of a thing, you know.
A trial judge.
Why don't we do this? Why don't we take this topic and your portion of it on the blood draw particularly, and move that to the next meeting as a singular subject in and of itself. Because what I'd like to do, and you're all welcome to comment. And by the way, the panelists up here are not the only ones who can comment. If you have a comment you'd like to make, you raise your hand or give me some indication you'd like to comment on this. But you, Todd, you made, I think there are 8 proposals or suggestions that you made in your slides. With the indulgence of the committee, I'd kind of like to take some of them. Well, I'd like to roll through them. Just want you to go back to the slides and just kind of roll through them. And what I'd like to do is take a moment to see if the committee's got any concern or question about those elements that they can voice at this particular point in time.
That's number one. Just restrict suspensions down to things that are directly related to moving violations and eliminate suspensions for things such as child support or drug possession. And I think Mr. Morrison could probably, Mr. Mitchell can probably speak more directly to the cost savings associated with that for DDS.
Chairman Golick.
Just a quick question, and I'd have to go back and look at it. It's been a while. Did we not address that at least to some degree with regard to some of the criminal justice in the various iterations of criminal justice reform?
You're going back a little bit before I actually was involved in this process, so the answer is I think so. I know there's been a relatively recent national study on the practice that we're generally favorable to this kind of thing, and it was directed at, like I say.
I know in one portion we went ahead and did address it on the felony drug side, not necessarily felony drug side, but on the drug side, and then I think in a subsequent chapter of criminal justice reform we had it apply on the DUI side as well.
You're going to have a better memory of that than I am, I think.
I believe that. Mr. Spouse, can you?
I know we've discussed a couple of what I'll call antiquated provisions related to drug offenses, and one of which is...
Oh, we removed the mandatory suspension. That's what it was. We removed the mandatory suspension and vested that back with the judge, correct?
No.
One way or the other, no?
We gave the judge authority to issue permits in drug courts and DUI courts.
Okay.
Gave them complete discretion and authority. So that's the one thing. The other things, the two things that we've discussed is the fact that we still suspend license in the state of Georgia over a drug conviction, whether it's related to automobiles or not. That's goes back to the early days of that's how we're going to fight drugs. And the other provision is the unrelated to this, but I think what you're talking about is Georgia's one of the few states left with a prohibition against receiving food stamps if you have a felony drug conviction. So there's two things that we've discussed in criminal justice reform, but never have made it into the bill.
Okay. Thank you.
Well, let me reiterate. Are there any? I mean, obviously there are some fairly aggressive things that are up on the board there. Can you put a fence around that in terms of the impact that this would have?
We've discussed that with Department of Driver Services, and as it directly impacts them, that's going to be all Mr. Mitchell.
I am scrambling for my numbers here as we speak. I will say that I looked at the suspensions that we imposed last fiscal year, and there were a few 100,000 suspensions that we imposed, and roughly 2/3 of those suspensions were for non-driving related reasons.
Oh, wow.
I looked at the number of suspensions that were reinstated for that same period of time, and a little over half of the suspensions that were reinstated were for non-highway safety related suspensions. So it's a huge number. And, you know, our Commissioner, Rob Michael, actually chaired a working group that was related to suspended and revoked drivers. It was a working group that was sponsored by the American Association of Motor Vehicle Administrators, which is sort of the umbrella agency for all the DMVs throughout the U.S. And, you know, what that working group found in working with a lot of the states is that, you know, when a driver is suspended, they're more than likely going to continue to drive. You know, when it comes down to, you know, their livelihood or, you know, whatever, they're probably going to continue to drive. So the thought is, you know, some of the suspensions that have nothing to do with highway safety, you know, there should be a concerted effort to get some of those off the books. Now, I'll be honest with you, some of the controversy that raises is that, you know, if 2/3 of the suspensions that we impose are non-driving related, then obviously that's a lot of money that generates for the state in reinstatement fees. So that, you know, is sort of a double-edged sword there, but I think it's definitely something that's worth exploring. Obviously, there's going to be some of those non-driving related suspensions that are very controversial, such as child support. I know that there was a news article recently in the AJC that talked about the effectiveness of those suspensions in getting, you know, the deadbeat parents to pay their obligations. So, you know, our thought is you know, something that may be too controversial for us to tackle. You know, let's at least considering doing some limited permits for these folks. It doesn't make any sense that you know, we don't have a limited work permit for child support suspensions today. It seems counterintuitive that, you know, in trying to achieve compliance, we're taking away a person's most obvious means of complying with the requirements by, you know, taking away the privileges. So I'm still searching for the numbers, the exact numbers, but that's sort of what we had in mind.
I am certainly not in your positions, but in terms of my knowledge of this, but I'll be asked a dumb question. Is there an ALS hearing, or is there opportunity for an ALS hearing on the failure to pay child support or the drug possession comment?
It is not an ALS hearing, but they do have the offender. Anytime someone's driving privileges are going to be taken away, they have a right to an administrative hearing. So they have the right to appeal that, but, you know, if it's affirmed, then they're faced with having to reinstate before they can drive again. There's no sort of limited driving privileges there.
Okay. And from the standpoint of resources, which you mentioned, Chuck, and public safety's interest in this particular area, the issue really is in a DUI offense, the officer's got to be, the arresting officer's got to go to the ALS hearing at this point in time. There isn't any requirement on the child support or the drug possession. I mean, those are, so that's off the table. It doesn't save anything except, you know, whatever time is involved and the people who are involved in that particular process.
Right. The DDS side of it, but I'll give you another absurdity. We talked about drug possession, but I'll use for an example, not that this makes up a lot of their suspensions, but your license can be suspended for a $10 gas drive-off, but it wouldn't be suspended for stealing something in the store and then getting in your car and running from the scene. I mean, so that's kind of some of the completely unrelated to actual public safety and motor vehicles is kind of really our point. And if that then frees them up to reallocate those resources to the other, because like when we talk about what I've discussed as the problem with ALS in the beginning, we're going to have to change that culture in law enforcement if we turn around and put some substance to an ALS proceeding that's going to take place early in the process and is going to have some meaning. That culture is going to have to be changed, because now law enforcement sees very little value in that process anymore. So that'll have to change.
So from the numbers standpoint, we're really talking about 1/3 of all the ALS hearings that are what you said, 2/3 were non-driving, so the rest of them have to be driving offenses. And I'm not sure what other offenses would require. Well, there's a whole bunch of them. I think you've probably got 14 or 15 different limited driving permits, don't you? Some form of them.
Absolutely. You have the under 21 school suspensions for absenteeism.
Right. Okay.
If a teen drops out of school before they turn 18,
Right.
they get their driver's license suspended. Under 21 alcohol violations, underage possession may not have involved the use of a motor vehicle. So it's a whole scope of different suspension types out there that's not related to driving.
And the feeling, and just to summarize, the feeling was that the commissioner's hearings on this, or the conversations he had on this, that most of those people are going to drive anyway. That particular remedy is not one that's effective. Is that?
And that's the true savings on the system, is if we eliminate 1/3 of the people riding around with suspended driver's licenses, then we're not arresting and processing and seeing them get into the perpetual cycle that unfortunately these judges will tell you they see. Is, you get a suspension probably for something unrelated to traffic. You get arrested for driving with suspended. You end up on probation doing that. Then you can't make it through probation. The whole cycle goes through there, and then you end up with another suspendable offense over it. And it's just a perpetual cycle that didn't, quite frankly, accomplish anything from a public safety standpoint.
Okay. Any other comments on that? There are a couple questions we have up here. Chairman Powell.
Thank you, Mr. Chairman. I served on the initial committee that dealt with criminal justice reform, and we heard from both probation and parole that because so many people are in the system because of drug offenses, that it sort of defeated the purpose when we're trying to make a condition of parole or a condition of probation that you get a job, yet you can't get somebody a license so that they can get to and from work. And we've got a prison in my district, Autry State Prison, and they've got an excellent volunteer fire department that assist all the other fire departments in the county, and very, very skilled people who then can go out and become firemen when they leave the system. And yet we've had very, very much difficulty in filling these positions and training these people because most of them have drug offenses, and we can't get them a driver's license. And so in the scheme of things, heaping on punishment sounds good, but if our overall goal is to improve public safety, we're not accomplishing that goal.
Agreed.
So I appreciate y'all at least bringing this forward for discussion, because I think the conversation needs to be had.
Thank you, Chairman Powell. I'm going to recognize Representative Fleming.
Thank you, Mr. Chairman. I'm trying to understand all this. It appears to me that you get punished when you get your license suspended for failure to pay child support or drug possession. When people get punished in that method, it causes problems, and Chairman Powell just mentioned some of the problems it caused. But is it your position that we're going to solve more problems by doing away with that than we're going to create by sending a signal that it ain't as bad as it used to be when you don't pay your child support or you get a drug conviction?
I think what we're I'm sorry. I think what we're balancing is the effectiveness of it. I think one of the reasons we bring the child support issue to a head is just as you just heard, there's no permit for that. You're suspended now until you get current, and there you can get an order out of the Superior Court saying you're current. You're not getting that reinstated, and that's counterintuitive to the concept of working and paying child support. So I think we say this is an example of one of the antiquated approaches. Maybe the approach on child support is we're not going to eliminate that suspension tool as a collection mechanism, but we're going to say we're going to suspend your license, but we're going to provide for a permit that you can then go into court and apply for and say, I've got a job, I've got a plan, I'm working towards paying the child support. That's not there now. So maybe that's the best approach to the child support. On the non-traffic related drug offenses, I think we really struggle with the logical connection at this point about what we know about drug offenders, what the approach has been with the accountability courts and the entire, quite frankly, criminal justice reform approach. Is it's counterproductive in the environments and the situations as the chairman just described, to blanket do suspensions on drug cases. I think that's our point.
So
Again,
what you're telling me is that the good from keeping some people working by giving them a permit or not taking their license to start with,
right,
if they get a drug possession or failure to pay child support, right, outweighs the good that is out there in society that says, you know what, you really want to pay your child support because they're going to come down on you hard and you're going to lose your license and all kind of bad stuff's going to happen to you. You're telling me one outweighs the other.
I'm telling you that you've got to make that decision. You're the policy decision makers in that. That's what we've done is frame the debate for you.
What is your advice to the policy decision makers?
My personal opinion is the blanket concept of suspensions, particularly in a drug offense that's unrelated to a traffic offense and no longer has anything to do with public safety, is an antiquated approach, and that I don't believe that there's more value to the blanket suspension there is to the flexibility of removing that suspension or providing for quicker access to permits.
And you're in this, you know more about it than I do. Obviously, sure. I can see that right away, so I put value in your opinion. But is that opinion based upon trying to evaluate something you can't really get statistics on, or is that based upon some numbers that really make you feel that way?
Well, we can show you numbers because he's got the numbers, he just can't produce them right now. We've seen them; they make up a substantial portion of the suspensions, and then my experience as a prosecutor, particularly in the lower courts, has been the perpetual suspended license situations these individuals get in, that they just can't get ahead and can't get over this hump because of the drug problem and other things, and it's just counterintuitive to the other approaches that we're now taking when related to these offenders. So I just talked in circles to tell you, yes, sir, I do believe we've reached a point where we need to reevaluate our approach.
My last comment is that I don't mind voting for something that appears to lessen punishment for these two problems. I don't mind doing that if I feel real strong and can make a real good defense that I'm doing more good than I am harm.
Yes, sir.
But I want that strong defense to be able to make.
Yes, sir.
Thank you.
Chairman, may I address that?
Sure.
Very briefly, I promise you. It's not been my experience that people make these risk-benefit, cost-benefit analyses when they go out and, for instance, smoke marijuana. They don't say, oh, I better not because I might lose my license. They don't pay their child support because they think if I don't pay, I'll lose my license. When I was first appointed, I went through the code. I found over 50 ways to lose your license in Georgia, to have your license suspended. I quit counting them. I quit trying to memorize them all. I think my personal point of view is what we're talking, the driver's license should be given to someone, the privilege of driving an automobile should be given to those who are qualified and have demonstrated their ability to drive an automobile safely in Georgia. These ancillary matters that might lose that, why do they contribute to public safety? Why do they contribute to the overall question of public safety? And that's what the whole licensing statute and scheme is all about, making sure that when we leave here today, we can drive on safe roads in Georgia. Because somebody has not paid their child support, while they may not be a very nice person, doesn't necessarily make them a less safe driver.
I appreciate that there's some logic to what you're saying, and I'm once again trying to weigh the balancing of the two. So my question for you is this. I know a lot of people don't hesitate to smoke a cigarette in front of a police officer. I think almost everybody really hesitates to smoke a joint because they know that they're putting themselves in harm's way. So there is some weighing that goes on that they close the door or get behind closed doors or off in the corner when they do this. People know if I break the law, there are consequences. So do we want to send a signal that there's less law to be broken now?
I don't think it would do that. What you're really trying to do is change behavior.
Absolutely.
Yeah.
And I just don't think that there's a correlation between driver's license loss and changing behavior of someone who wants.
Then why do people hesitate to smoke a joint in front of a cop?
Well, my guess is I've never seen that come before me where they're doing it in front of the cop.
Because they're not stupid enough to do it. They know to get in trouble. That's my point.
Everybody knows you can go to jail if you do that.
Right.
But they don't think at the same time, I can go to jail, oh, but let's not do it because I might lose my license too. They don't think that way.
Right.
Okay, let's move to Representative Quick.
Thank you, Mr. Chairman. And my question's about child support. And it certainly is true that when there's an arrearage and you're dealing with the Department of Child Support Services for collection, it's an automatic suspension when they confirm that arrearage and they do it, and there's no opportunity to be heard, and as you say, no opportunity for a limited driving permit. And that's counterintuitive and certainly needs attention. I think everybody would agree. But have you checked with the child support, either the Child Support Commission or the Child Support Services folks, to determine exactly whether there is a correlation ultimately between any collection, which would save the state of Georgia money in that process when they're collecting, I believe we'll find, and the driver's license suspension?
We have a number of DAs in this state that under a contract with DHS actually handle and process or prosecute the child support recovery actions and what have you. And there is a correlation. I don't want to dispel the fact that there is a value in this process, and here's what happens. There is a group of non-compliant parents that when they get the notice that their license is to be suspended, all of a sudden get current and caught up. So there's some method of that process that does have some application and some effectiveness. I think our position is, though, a blanket suspension that takes place and then stays there without any permit or anything else takes that person that was not going to get compliant just because of a notice of suspension, and I'm not going to get compliant now that their license is suspended, but is trying to get compliant and needs to be able to drive to and from work and that kind of thing, needs the ability to do something differently that we don't have in the process now. So there's going to be some sort of balance. I think at the end of the day, as we look into this, we're probably not going to want to, my recommendation would not be to completely eliminate the concept of a suspended license, but also not do it in every non-compliant case. And even if you do it in every non-compliant case, let's come up with a method by which once you get that offender's attention and they're trying to move forward and work, that we give them some mechanism of doing it.
But in response to Representative Fleming's concern, that can be quantified. I mean, is what you're telling us. We can get those numbers and work with the Department of Child Support Services to see whether that works as a tool for those children who may be receiving, and most likely are, public assistance.
We'll have to ask. I don't know that they can directly correlate that I got these 5 offenders actually got caught up or started making progress because of the suspension notice or because of other actions to collect it. But I think we should certainly ask.
Thank you.
Well, thank you. Chairman Golick, a final comment.
Thank you, Mr. Chairman.
The
Judge really made the point better than I could, really, to Mr. Fleming's point. And I understand Mr. Fleming's point about sending the wrong message. I think I'd have to agree with the point the judge made that people they're paying child support not because of a fear of losing their driver's license. I don't think the thought process goes that far. Whether that can be statistically quantified, probably not. But if you take even one step further, to me it comes down to the best interest of the child. When Ms. Quick is representing one of her clients in her practice, ultimately what's in the best interest of the child, that system, that rubric, that foundation in place that will allow earning, to some degree in order to go ahead and affect that arrearage and that resources go into that child, because that's the end game as far as child support goes. So I don't practice in that area, but even I know that. So I thank the judge for making the point so well.
And as we've already discussed, that just forces another decision, and that is, am I going to drive without a license or not, and keep my job. So I can pay the child support. I mean, this whole thing does cascade fairly quickly. This may be a little bit, the reason that we're talking about this is because it's within your suggestions for improving in the ALS system. It's not necessarily related to the DUI issue as we're here to consider it, but it is an influence on the whole ALS process, and I kind of assume that this is another issue for probably another type of a bill or any legislation to address that may or may not fall within this. Or maybe I'm wrong, but let's move on to the second point you've got. Maybe we can go. Maybe some of these are a little more obvious than the others.
Second point is simply that if the idea is to encourage compliance, if that's what we're driving towards, then it makes no sense to impose an administrative suspension on someone who took the test, regardless of what their BAC is, because they have done what we wanted and they took the test. So the consequence should only attach to a refusal, and that's the whole point of the second one.
As far as the ALS hearing is concerned?
Yes.
Okay.
And kind of a related point to what you're talking about in terms of law enforcement resources, the statistic that GOHS has that always grabs me is that only 20% of officers actually show up to a hearing after filing a 1205, about 1 in 5. So if you eliminate some of those hearings that are based upon a BAC, because again the person complied, then you're going to reduce probably that reluctance to show up because they know they're actually dealing with someone who did not do as they were requested to do under the implied consent statute.
Any other questions on that particular point? Do you have one? Or okay, I'm sorry, I didn't turn you off over there. Let's move ahead. This is the one on, go ahead. Why don't you explain it?
Sure. When we get into a situation where you've had someone who's refused, they basically have a choice that they have to make at that point, and that is either to request a hearing or not. And currently, there's a 10-day window within which they request that hearing, they pay the filing fee, and if they do those two things, then they get the hearing. So this first point deals with those who make the choice not to go forward and request a hearing. The consequence for those offenders would be that within that 10-day window, they would be suspended automatically by operation of law, with the provision that they would be allowed to immediately apply for and obtain an ignition interlock limited permit, much like the one that we currently have. And again, that would not be limited to time, place, and none of those things. It would simply be based upon the installation and use of an ignition interlock device. And again, we would look at the length of that imposition based upon their DUI conviction history. And like I say, we have not got into any significant detail about what that length would look like, other than to say that we would allow credit for those offenders who remain compliant towards their post-conviction suspension period.
I'm just looking at the number of refusals that you've got here. Mike, you correct me if I'm wrong. It looks like in 2013 it's about 11,000 or so. Is that right?
That's correct.
Maybe 12,000, something like that. 11, 12,000. So that's what you're really talking about. That's the population you're really talking about. Okay. But the okay, I got it. I was looking at it. Hold on a second. Let me just look back at this for a second and see if I can line this up a little bit. But the number of administrative license suspension hearings on a first offense were 11,391. Am I doing the wrong numbers here or what?
No, sir, that was correct, I think.
Okay. Okay. All right.
ALS suspension.
So are we saying that the number of refusals is the same thing, refusals equal the ALS hearing effectively?
There are two grounds upon which you can actually trigger the administrative process, and it's actually reflected in the implied consent warning itself. If a person takes the test but they're over the limit, they can be suspended basically along the same lines, although it's a little less permissive under those circumstances. Right. Refusals are, that's the population base that we are targeting.
Okay. All right. And so you think, so what you're suggesting is that that's worth it in terms of the number of refusals that we've seen, and that's the, it just seems like that number is, compared to what you're talking about, Mike, in terms of the number of ALS or hearings or limited driving permits that are requested.
Well,
I mean,
Mr. Chairman, the numbers
numbers
for the ALS, those are the numbers of ALS suspensions that we process, not
right.
necessarily the number of hearing requests that we get.
Okay.
So, nothing on my graphs here indicate the number of hearing requests that we get. That we could get that information through the Office of State Administrative Hearings, but I didn't have that in any of my charts.
How many? Do we know how many limited licenses are granted from ALS hearings as a percentage of the?
Well, the limited driving permit is issued after the DUI conviction. So the ALS and the underlying DUI, they sort of take different paths.
Oh, you're right. Okay.
So the issuance of the limited driving permit from the DUI conviction is not predicated on any certain outcome of the ALS.
Okay.
I think the flaw with trying to tie the two numbers together is the ALS total suspension numbers that you've got is a result of both the convictions, the .10s, and the refusals. You've got a large number of DUI arrests that don't go through the ALS process until the suspension. So to try to tie the number we've got for refusal that start the ALS process to the number of ALS suspensions is leaving out all the DUIs that did not start the ALS process.
Right.
Right. It could have been a less safe DUI case where the person didn't have to meet the per se threshold.
Right.
In less safe cases, the ALS process is not.
Or the 1205 form was just never done.
Mm-hmm. Right. And that happens quite a bit.
Right.
Chairman Golick.
Thank you, Mr. Chairman. Just on that particular slide, I'm just reading from the handout. In the contemplation of the offenders being allowed to immediately apply for the ignition interlock, and of course that goes to the overarching priority of making sure that somebody that's had a DUI or suspected of having a DUI, as if they're driving in a safe manner in the interlock, I assume, will ensure that. And that's consistent with, I think, criminal justice reform, to go back to that point earlier, because you've got somebody then continuing to earn for their family priorities, but not being a danger to the public on the road. When you say immediately, is there a and I realize this is a framework, so if the answer is I don't know, that's fine. Is there a contemplation on what the time frame would be on the application there?
I believe the time frame we're talking about would be similar to what currently happens with first offense affidavits, and that is essentially you're suspended by order of the court, you walk out with that affidavit, and as long as you don't drive yourself to Department of Driver Services, you can take it immediately and apply. So when we say immediately, it would be as soon as the offender who is suspended by operation of law can get to the Department of Driver Services and make the application. That would be the time.
What's the process on that from just a real paperwork? Is it a paperwork turnaround? I mean, obviously the ALJ is making the determination. Is that a correct statement?
They would issue the paperwork reflecting the suspension and the eligibility to apply. Department of Driver Services would have to say, but I know personally from my experience in the courtroom, there are offenders who put their plea in before noon on a plea calendar and are at the Department of Driver Services with a friend by 3 o'clock that afternoon and walk out with a limited permit.
And I'm sorry, but we're talking about the ALJ and that circumstance?
I'm using it as a parallel.
Okay.
The time frame we contemplate would be very, very quickly.
Okay.
As in the ALJ issues the suspension.
Okay.
Usually those are night court hearings, so by the next morning, the offender could take that paperwork to the department, present it, make the application, and walk away with the ignition interlock permit.
And when you talk about the time an offender must have the permit would be tiered based upon their DUI conviction history, we'd still be retaining some discretion for the ALJ to have some discretion there in that tiering? I guess number one, it's can you talk to the tiering,
Sure.
and then what discretion is there? Is the contemplation a hard, defined, no wiggle room for the ALJ, or is there some discretion retained in there?
I believe we're talking about a hard to find, no wiggle room for the ALJ. But for example, someone who comes in and has been charged for the first time, and these are just numbers I'm making up off the top of my head, but you've got absolutely no DUI history whatsoever other than the current arrest. Maybe it's a 6-month period. A second one, maybe a 12-month period.
Sure.
A third, 18 months, something along those lines. And again, we haven't fleshed out in detail what the tiers
Sure.
look like.
Mr. Chairman, those tiers are in statute now for
They are.
other permits and that kind of thing. So that's the current structure, would be to put it in statute.
Okay. Thank you.
Okay, let's move ahead.
Chairman Rice?
Sure.
May I inquire the presenter?
Sure. Yeah, why don't you give it a try? This is Christopher McClug, right?
McClurg.
McClurg.
Yes.
Sorry. You're an attorney in Lawrenceville.
That's correct, Your Honor, and I do quite a bit of DUI defense. I guess one of the questions I had as it relates to this suggestion is what the constitutionality is of allowing a license suspension for a refusal to go on beyond post-acquittal. So if somebody gets acquitted of a DUI, is it constitutional for the ALS suspension to continue? Now, when you get an acquittal or you get a reduction down to a reckless, then that suspension is sort of terminated. The ALS suspension is terminated. I just didn't know if that would be lawful to continue the suspension beyond an acquittal. I don't know.
You guys want to comment?
Oh, we got to comment.
You're in terms of constitutionality, I feel like I'm at a law school exam. I believe the thing that would be triggered would be double jeopardy. I mean, are we prosecuting for successive offenses, or are we imposing a criminal sanction for something that is not a criminal offense? My estimation is that as long as you are dealing on the administrative side, where you are simply imposing an additional condition upon the privilege of driving, you are not, as the courts define it, dealing in the world where you're imposing a criminal sanction that exceeds the maximum length of the penalty authorized by the legislature. So you're in a different world.
So long as you do so with due process.
Which would be the hearing. Yeah, exactly right.
Okay. Which puts us back into the administrative license
That's correct.
appearances and things like
If
that.
you take that argument and try to make it logically back, then we shouldn't be able to do any of this until there's a conviction.
Yeah.
As long as we've got due process, this administrative license suspension will pass muster from a constitutional standpoint. And that's been challenged in our courts before.
Right. You wait? Okay. All right. Well, let's move ahead.
Point 4, is that correct, Mr. Chairman?
Yes, it is.
Okay. Currently in existing law, we have what practitioners refer to as the four corners of the ALS statute, and we try to define the limits of what the administrative licensing hearing is supposed to be about, and we do that in statute. That is somewhat loosely adhered to on the best day. The idea here is to try to really narrowly focus the streamlined process on whether or not the warning was given, that it was the correct warning, and whether or not there was a refusal. So we could make clear, and this is just an example that plays, but it's one that doesn't really bother me, but in some courts, when you're having the judge address the issue of a reason for a stop based on articulable suspicion, sometimes they pull into that the constitutionality of a roadblock that might be in play. That requires a separate constitutional analysis that really isn't focused on whether or not there was a refusal or not. So the thought here is to narrowly define the scope of a hearing as far down as we can so that they are really looking at the issue that's bothering us, which is trying to encourage compliance with the implied consent statutes. So these are just some of the things that we point out that are clearly within play that need to be considered for that to take place. And again, that would be articulable suspicion, the development of probable cause for arrest, the implied consent warning itself. Was it given on time, or were there exigent circumstances? Was it the right warning for the right age of offender and the right class of vehicle? And then whether or not that offender complied as that compliance is currently defined under Georgia law.
Any questions on that particular? I mean, I think the point's obvious in terms of what you're trying to do, and
I guess the question I really have is, don't you need the officer to show up to, make this happen?
That goes directly back to the point Mr. Spehaus made, which is we have to change the culture, and quite frankly, I see that as falling somewhat on my shoulders, because it's my job to go out into the field on a routine basis and be interacting with our prosecutors and our law enforcement and bringing that training to them. I can tell you that currently, under our current training structure, 20 different times in a year, I am all over the state of Georgia, and 1 hour of the training block that I deliver is devoted exclusively to administrative license suspension issues. And my message is always go, because the statistic that follows up on the back end of that 20% that I told you is this. When there is an administrative licensing hearing, 95% of the time the department prevails if the officer is there. So the fight is in going. So I can tell you that we are aware of that, and yes, it involves changing the culture, and we think that if we do change the culture in this way so that it encourages people to go ahead and take the test, we'll be in a better world to make that argument to the law enforcement who actually have to do the job.
So these are articulated in a fashion to limit the opportunity for the defense's discovery effectively with the officer unrepresented.
That is the notion, yes, sir, because it is very unfair for the officer to be there in the position of defense attorney and witness, and they're at the same time having to bring forward the facts that they observed and trying to fend off attacks that they're not prepared to do, that they're not trained to do, that they're not aware are coming at them based on the nature of the hearing. So it is intended to tailor that a little more narrowly to the intent of the entire process, which is to encourage compliance and to make withdrawing licensing privileges based upon failing to provide a test as you're requested to do.
And that'll make this is within the due process prescribed limits, basically.
This is something that already takes place at ALS, yes. It narrows it a little bit. There's no due process issue.
All right.
Mr. Chairman, I feel compelled to comment on that. If it is being suggested to take away the requirement that the officer articulate no articulable suspicion for the stop, no probable cause for the arrest, then theoretically the officer can go up to anybody who's driving, completely sober, ask them to take the test. They say, I haven't been drinking, I'm not going to take a test. They've done nothing wrong, absolutely nothing wrong, and lose their license. That's scary.
No, we concur, and that's the exact opposite of what we're saying. That's the exact opposite.
You're not talking about taking it away.
Just keep
that was scary.
The exact opposite.
That was scary.
Number one you found.
The exact opposite.
Okay, I don't have the.
Yeah, they're there. Yeah.
Okay, very good. Thank you.
Well, I'm glad you caught that.
Well, I'm paying attention, but I'm just my payments are not always on time.
Okay, but this goes along with meeting the requirement that public safety is set down in terms of limiting the officer's exposure. Okay, the fifth one. Let's just move along.
This simply tracks what happens in the world where the offender does pay the $150 filing fee and elects to have a hearing after their refusal. The idea would be as if the hearing goes forward on the limited grounds articulated and the suspension is upheld, essentially the penalty tracks exactly what would happen to those who fail to request a hearing entirely, and that is you're suspended. The length of the suspension is based on your history, but you are again able to immediately apply for that ignition interlock limited permit and continue you're uninterrupted on your driving privileges as long as you remain in compliance with the permit.
Okay. Any question on that one? Any of the committee members? All right. Well, I think we're getting down to some ones that we can move through a little more quickly. Why don't you head in that direction, Todd?
Number 6, this one simply goes along with the discussion we had about what type credit the offender who is compliant with the ignition interlock permit would receive towards their post-conviction suspension. Our thought being that as long as they are compliant, whether it's without requesting a hearing or with requesting a hearing, if they do what they're asked to do and there are no reported violations on the ignition interlock device, then they do receive that credit. It's conceivable, if there are not corresponding changes made in the current tiers under a DUI conviction, they may be able to completely eat up their entire suspension that would be imposed post-conviction on the interlock permit, especially if they keep that interlock permit and the trial is delayed for some reason. They could completely eat their entire post-conviction requirement by just staying compliant before trial.
We've had some discussions about being the non-compliant, where they, with the checks made of the device, and we find out that they aren't compliant in one way or another. There's been suggestions that in other states, the way that's managed is it's simply an add-on to the length of time that you need to have the device installed.
That is the way some of our sister states do that. That's correct. We suggested a slightly different approach, which is in point 7.
Let's move it.
And the point 7 would be this. If you are imposed an ignition interlock permit pursuant to an ALS procedure, whether it's by waiving a hearing or going through it and having it sustained, if you violate that ignition interlock permit, you can be prosecuted for a separate criminal offense. This kind of lines up with other states who have actually elected to criminalize refusal entirely. Here we're not criminalizing the refusal. We would be criminalizing the refusal to comply with the terms of your ignition interlock permit. So it's moving it one step back, and that's something we thought was more appropriate. We would provide that separate criminal offense not merge, much like driving under the influence, endangering a child cannot merge into other offenses. It would be that same type of thing. The offense could not merge. It would disallow any post-conviction credit. So if you do this, you do not get the credit that you would get for the DUI. It's off the table entirely. And it would be punished much like suspended license is currently punished based on 121.
Chairman Powell.
Couldn't you accomplish that same thing by just saying that if you're driving and non-compliant with the interlock provision, that you're basically driving with a suspended license and not make it a new separate offense?
You could put it in that code.
You could, absolutely. That is very much one way to structure that.
Yeah. I don't know if this is on. Can I make one comment?
Bob.
In the idea that the offender has failed the test of the ignition interlock is one that's been addressed in so many different ways in the different states. And, the idea is to keep the offender compliant for a long period of time. I say long, an appropriate period of time, in order to have a behavioral change. And so if it's, rolling along in that you don't have non-compliance, let's say for 6 months, if that's what the statute says, or a year, if that's what the statute says, then it's the kind of thing that you've kept that offender in check with a behavioral change. So that's what we always look at. And what we don't want, I don't think, is something that would take away a tool here that ensures compliance. So I understand the idea of a separate offense, but you still want to have the tool of this driver not being able to drive the vehicle unless that driver is sober, and to be able to do that for a very long period of time. So that's, I think it's important from a practical perspective and a behavioral side of things, is that, if you're on the ID for a year and you've not blown positive, you've had a behavioral change because you're driving every day. That means you can't be drinking like you used to. And doing that for a year has a very strong way of changing behavior versus today when, you're playing the game of, do I get caught or not? Or I may have a few and it wasn't a problem. But you're not going to start the car if you've had one. Right. So, I'm not saying anything against it at all. What I am saying is just keeping the idea of this device working for that offender, no matter what tool of sanction you use, whether it's the new offense or not.
Was that part of your thought, or was it not?
I don't think, based on the way we've suggested this, that the ignition interlock requirement would be withdrawn.
Okay, and that probably echoes what we're saying similarly, just making sure that these things kind of work in tandem, whatever the outcome is at the end.
Any other points on that? Any other comments, audience or anybody else? Okay, let's move along.
The next one would simply be that the administrative penalty would be completely isolated and insulated from the criminal charge. In other words, if there is a refusal to comply, that refusal is administrative in nature truly and not criminal in nature at all. So that the ignition interlock requirement would remain until that term of suspension expires, at which time it would simply fall off and they could reapply for a full-blown license. And that would be regardless of whether they were pled guilty to a lesser charge or were acquitted. There would obviously not be any post-suspension conviction period to deal with, so there's nothing to credit. They just get through the period and they're through. Right. And that would be based on the refusal alone and it is not tied to the criminal process in any way, shape, form, or fashion.
That's a very good idea.
So if it's pled down to reckless from a DUI, they still have the responsibility of,
Yes.
It's considered as a licensing issue with an interlock requirement.
Yes, just a pure T example, if a first offender refuses and they are later plead guilty to or are convicted of a reckless driving charge and it's a 6-month period, they would still be required to complete that 6-month period with the ignition interlock permit. If there is no conviction for DUI, there's no corresponding suspension that goes along with it, so they just are through and can reapply.
Any comments?
Just one observation, and I'm not speaking for the judges on this, but I've heard well the whole idea of discretion and sometimes those instances where you want the solution, namely the IID, but you may not want the particular other sanctions associated with it. So we see a lot of pleading down in many instances of DUIs. This continues the solution no matter what the pleading down is. Now, I think that's an important component of behavioral change of the offender.
One additional point that's worth noting here is even if you do get a plea down or a conviction to a lesser included, the judge still has the discretion to impose an interlock as a condition of the sentence. So it's still possible to continue them on an interlock device regardless. It would just not be a function of the administrative process. It would then become a function of the criminal process, much like what we see today.
Okay. I don't see any questions on that. Why don't we just move to, I'm sorry. Go ahead.
To further clarify on that very last point, in fact, the judge can impose an interlock on a first right now if they wanted to.
Absolutely.
Okay, thank you.
But rarely do.
Well, let's go to the last point then.
Very good. And it would simply prohibit law enforcement officers from entering into those joint withdrawal agreements. I believe, and this goes back to something Representative Fleming asked, does the good here outweigh the bad? Is the good that comes from currently, under our current law, allowing a joint withdrawal to be admitted as evidence of guilt, is taking that off the table on par a good thing relative to getting the officers out of the negotiation process and out of the practice of criminal law? On balance, and there's a good bit of back and forth that goes on about that, but on balance, we believe yes, because it does take the officers out of that uncomfortable, awkward position. And again, the idea is to further insulate the administrative process from the criminal process by simply cutting another tie between the two.
Okay. Any questions about that?
Mr. Chairman, if I may.
Sure, Judge.
I want to echo and commend that particular proposal. One of the most frustrating things I ever did was have someone who was arrested for DUI, refuse the test, go to ALS, make a deal with a police officer, come in, negotiates the plea with solicitor, and often they were pled down to reckless, if you want to call it that. It's not really the correct term. Or even plead guilty to first offense DUI. And I have to impose an inappropriate sentence or review the plea bargain, whatever it is. I don't have a blood alcohol content. It's the most important thing we have to judge whether or not the sentence is appropriate for that person. And it was just tremendously frustrating when there was no sanction from the state. You get a plea down to a reckless, and I'm here trying to decide whether or not the thing I write my name on is or is not going to allow or contribute to this person going out and reoffending. So I commend that.
Okay. Any other comment? Thank you. Any other? I'm sorry. Why don't you come on up to the microphone and give us your name and certainly make your comment.
Good morning. My name is June Killian. I'm here on behalf of Frank Rotundo, the Georgia Association of Chiefs of Police. And I do believe that removing the law enforcement officers from being in any way involved in the disposition of the criminal case in this way would be beneficial. I don't think that most law enforcement officers, when they make a DUI arrest, want to see somebody continue to drive in that unsafe fashion. And a lot of times that we have seen when law enforcement officers were involved in some kind of joint withdrawal agreement. It wasn't their own want for the people to get back out there and drive. It usually had to do with somebody else requesting or asking them if they would do that for multitude of reasons, I'm sure you can imagine. So I think this, keeping the law enforcement officers out of that part of would actually be very beneficial.
Well, since you're here and since you made yourself known, representing these good folks out there, do you have any just comment on the general reason why the numbers of DUI convictions have dropped? From a high of 43,000, 44,000 down to 32,000.
Well, I'm sure defense attorneys would like to say it has to do with their abilities.
Yeah.
I think some of it, there's a lot of issues that I'm listening to today. The interlock devices, they're very expensive. A lot of people can't afford those. And I think sometimes in the prosecution, in the sentencing, they take that into account. And, like nursing licenses, if a nurse gets a DUI conviction, that can affect their licensing. So I think there's a lot that goes into it. I'm
just looking for an answer as to, is there an answer that says that the officers are just not, or they're pleading down to reckless, or they're not doing these DUIs at the same level that they used to?
I think they're doing the DUIs better, working them better than they used to.
That's interesting. Well, thank you. Appreciate it. Thank you for coming. Any questions? All right. Okay. Excuse me.
One thing I did kind of think of on this point that goes along with that culture change we've been talking about, and it just occurred to me as she was speaking, when you take away joint withdrawal, you do have to realize that you're putting an officer in a situation where if he doesn't show up, nothing happens truly, and that is also a form of officer discretion. So we need to think about that as we go forward with it, that there could be that unintended consequence, that if we don't let them have any say at all, then they have the final say by just not going.
Showing up.
So that's something that needs to be considered as part of this as we move forward through it.
Okay. Well, just from the standpoint of kind of summarizing this ALS process and where you guys stand with your suggestions here, and then dovetailing that with the DUI study committee recidivism ideas in terms of using the device, using the interlock device, it seems, just from what I've been able to read here, that there should be a higher level of participation with the use of interlock devices if, in fact, you go forward with this.
You would increase it at the administrative phase, which is earlier in the process,
right,
and you would increase it for essentially everyone who refused. They would either have the choice of, let me rethink that. You would eliminate from the process people who complied altogether, so that wouldn't even be on the table for them. So taking the test has its own benefit. For those who refused, you would get all of those people under an interlock device, either because they choose to be there because they don't request a hearing, or after a judge finds that it should be imposed after a hearing, and if they don't, then they just have a hard suspension period that's tiered based upon their prior conviction history. Mm-hmm. So yes, it seems like it would push the population out and accomplish that goal at an earlier stage. It seems like it would do that. And hopefully improve compliance with the process in general.
It seems like you've taken into consideration some of the same things we were thinking about in terms of where this committee was headed on improving the circumstances under which DUIs are managed. Is there anything else that we want to talk about here from an ALS standpoint? Or okay. Well, it's been suggested to me that we ought to take a 10-minute break if somebody wants to take a break. Anybody want to take a break? Because we'll move right ahead and move. I'd like to move into the masking issue that we've considered and talk a little bit about cost too. We have a, Mr. Chris, you've got a little piece of paper here that you've presented.
Yes, sir.
You brought it yesterday. I don't think anybody out there has had a chance. Why don't you just summarize, come up to the microphone and just summarize
Certainly.
what your thoughts are on this issue.
Chairman Rice, as I said before, I'm a defense attorney. I'm an attorney in Lawrenceville, and I do a lot of DUI defense as part of my practice. I can tell you, though, that the genesis of this idea is not to be helpful to DUI defense attorneys. In fact, as I presented it to some of my colleagues, they're not enthused about it. They're sort of neutral to it. So I just that's sort of the backdrop. It really started when I was looking at the conditional discharge and the first offender treatment that we have for a lot of other crimes, and then looked at the unavailability of either diversion or conditional discharge or first offender for DUI. And I certainly understand the basic concept behind that, but as I talk to folks, solicitors, elected solicitors, state court judges, police officers, and other folks, as it relates to that mismatch between allowing conditional discharge or first offender for aggravated assault, but not having any benefit for somebody who gets a first lifetime DUI, I think the public sort of scratches, it's a head scratcher for them. And so I undertook modifying conditional discharge 1613-2 to encompass first lifetime DUIs. And certainly I had no idea that this was going on. This sort of segued from some conversations I had in Gwinnett. But at the end of the day, what this really is driving at is a balancing act between, one, not having a DUI on your criminal history in certain circumstances, and you can see them, I've kind of laid them out, BACs, which is an issue. The judge was speaking about BACs. And there's a lot of other conditions, but it balanced that, and then one of the benefits, which I think this committee is certainly concerned about, this I almost refer to as an anti-refusal statute. This encourages breath tests because there's no mystery amongst sort of the public at large and criminal defense attorneys that the standard maneuver for a DUI is just refuse. The pain is just not there to do anything other than to refuse. And in talking to state solicitors, they want more tests. You want more tests. And what this does is it would modify the implied consent just a little bit to tell somebody, and it'd modify the law, to tell somebody if you refuse, this is roadside, if you refuse, your ability to qualify for conditional discharge of first lifetime DUI is voided. You don't have that ability. Word will, if a statute like this was enacted, and word would get out on the street very quickly that, look, the idea now is not to refuse anymore. I mean, the idea will be, look, don't refuse, give a breath sample, and if you give a breath sample, then you're eligible, at least with certain conditions, for conditional discharge. And so you'll get more compliance. And when I speak to state solicitors, essentially what they say is, look, and I don't think it's any mystery to folks who've prosecuted these cases or judges who have sat in jury trials. You asked the question about why DUI convictions are down. DUI convictions are down for a number of reasons, one of which is the word on the street is just refuse. It is almost impossible. I've tried dozens of refusal jury trials and breath trials. It's almost impossible to get a conviction on a refusal. And so the reason I think state solicitors will like this is because people will be given this implied consent that says, hey, look, if you refuse the breath test, then your ability to qualify for conditional discharge is voided or you don't get that. That's going to trigger these marginal breath tests. Now, I've put the BAC at 0.12. I initially had it at 1.5 because the nolo contendere statute is 0.15. although the null contendere statute has zero effect, nobody uses it anymore, it's never used. So that number could be moved around, but I think what you're going to get is you're going to get a lot of people who are 0.10, 0.11, 0.089, in that range, who are scratching their head and thinking to themselves, I've probably had one more beer than I should. I've always been told to refuse, but the police officer just told me, and I know from speaking to friends and so on and so forth, that if I refuse, I don't get this conditional discharge and it'll never come off my license. So that was sort of the genesis of why I thought that conditional discharge for DUI ought to be an option. It's going to get more tests. There's a lot of other benefits that a conditional discharge sort of gives the person who complies. You're going to have all the trappings of rehabilitation, treatment, and you can see where I've sort of changed the statute. I think this would be done. I think state solicitors would do more of these cases, or take DUIs and put them in diversion, but you can't do DUIs in diversion because the statute says that if you have a mandatory sentence, you can't divert a case. So I think state solicitors would welcome this because it's going to give them more test cases, which are very hard to beat in jury trials. And it's going to give a judge a lot of flexibility as it relates to treatment. You are going to get, I think, more compliance with people as it relates to wanting to protect that. That is, to be on probation for a DUI. If you know you've got a DUI on your record, I'm not saying that you just sort of blow everything off, but if you know, hey, look, I have to do everything by the book, and I've got to get all this done and done correctly because I have this conditional discharge benefit that's possible, I think you're going to get a lot more people who are compliant. You're going to have less probation revocations. It's less expensive, obviously. Those can be sort of expensive, time-consuming. So I just think that the time has come sort of in the collective community, in criminal justice reform, as it relates to DUIs, as it relates to sort of this category of DUIs, which is some blood alcohol or lower. I always thought that always stunned me. To be honest with you, a .27 DUI in Gwinnett County is not treated any different than a .081. It's not. And so this, like to the judge's concern, there's going to be people that are going to meet this, but there are also people that are going to give a sample that's going to be .17 or .23. They're going to think to themselves, okay, because I hear it all the time in my practice, so I was fine. Well, then why'd you blow a .23? So people on the roadside aren't thinking to themselves, well, I'm .23. They think they're .08 or .09. You're going to get a lot more samples. Then you're going to give judges the power to see what that is, and which I think is the judge is right on. That is the key sort of factor in determining what punishment should be. And what sort of problem that person has. There's a big difference between a .11 of some 40-year-old person and a .29 on some 21-year-old person. So that has to be taken into consideration. So I certainly understand why refusals are troubling to judges for that purpose. So I just think that this will sort of help folks who are within the bounds. It will force compliance, and this is a benefit. I think a lot of what's going on with ALS and so on and so forth is sort of the stick approach to kind of whip you over the head if you don't comply, which I get. That there has to be some stick. But this is sort of that little nugget, that little carrot. If you sort of in this range and you comply, you get this treatment. And so for capturing more tests, which are going to get more convictions because you're not going to have these refusals, you're going to have more DUIs, and then you're going to have some people who actually get the benefit of sort of this proposed statute. So I've talked to a lot of people across a lot of different kind of groups and have not received any sort of major pushback. Again, I've talked to state court judges, I've talked to defense attorneys, state solicitors, police officers. One of my best friends is a DeKalb County police officer. So it's just something that I think the time has come and it recognizes sort of a rehabilitation side and a carrot side, as well as encouraging compliance by these breath tests that are so concerning to the judges and certainly this body. So,
well, Chris, you have certainly engendered a couple questions for yourself.
Yes,
and so the first one comes from Chairman Golick. Wade. Representative Virginia. Oh, I'm sorry. 18. You're 18. There we go. Well, close enough. Mr. Setzler.
I've been reserved there, Mr. Chairman. And I don't want to over-focus on a specific proposal,
Yes,
and I appreciate your words. My concern is if there's if, as you say, there's a tendency to not get convictions if people refuse, and we create an incentive for folks to blow because you obviously have your full reinstatement and you've got the ability to be treated in a much more favorable way if you do blow, but yet you put a BAC level in there of 0.12. I'm concerned that if someone's driving and they think, I don't really know what my BAC is. I've never blown before. I don't know if I'm a 0.1 or a 0.18. They have no way of calibrating where they are to your point. If we insert in this, if you blow and you blow too high, then too bad. You blow. You've given the evidence. You're going to be convicted, and you can't be treated with more favorably as a result of doing that. Then you really void the incentive to blow. I do think there's some values to us creating incentives to blow, but at a 0.12, if you're treated differently above that, I think that muddies the water and candidly doesn't fix the problem. What's your approach to that?
I picked one too, sort of, and I understood that. I mean, what you'd say is it would capture a whole lot more, and you'd give a whole lot of people the ability to fall under this, and sort of that's sort of a policy question, because it would always be in the discretion of the judge, right? So you could take a BAC limit out of it, and then just let the local judge determine for themselves sort of the facts and circumstances and whether they're going to allow this conditional discharge and without concern of a BAC. I just didn't want I didn't sort of want it to be open-end where then the comeback is, well, look, I mean, you can basically drive around drunk as you want to drive, and as long as it's your first one, you do X, Y, and Z, and you're good to go. I wanted to signal to the public, hey, look, there's this, because there is this paradigm. I know solicitors and police officers and folks don't want to talk about sort of the garden variety DUI, but there is such a thing as a garden variety DUI, or I guess a less serious, and I'm being sort of sensitive there, but there is, I can't tell you how many cases I've defended that are .082, and the guy is saying, I had a little too much. I mean, he's getting convicted, let's face it. I mean, on a road stop where he admits, yeah, I've been drinking, yeah, I blow, it's .082. I mean, it's slam dunk conviction straight to the state court. So there's that case where it's your first lifetime DUI, you blew on .082, so you're not kind of abusing, this alcohol. You're not in that .17, .19, and sort of up in that echelon. So you would signal to the public, hey, look, if you had some on the margins, you're still available. But again, if you took the BAC out, you could let a local judge say, hey.
Yeah, I mean, I don't want to interrupt you. I'm following your line of reasoning. I guess, we, those who don't come to these committee hearings much may be developing a perspective of what's being said here. This is not a polarized issue. There's not one camp that believes this and one camp that wants that. And we're trying to pass good policy. And there's certain things that are inherently judicial decisions. There's certain things that are inherently legislative in nature to pass. I don't know that we have to draw a line for what is DUI, what is not DUI. So there are bright lines we've got to draw in law. But I would just share with you, I'm nervous that if we're trying to create a structure where we're incentivizing folks to blow, go on the record, that I would read this with a .12. If I'm and I'm not a practicing attorney, if I'm someone's street lawyer advising them, I'd say you're rolling the dice that you're going to be between 0.08 and 0.11. You're crazy to blow because you're on the record for it. This really provides no incentive for folks to come to the table and blow, in my view. I just wanted to share that with you.
I certainly understand that, and that would sort of be a decision that everybody would have to make as to whether they're comfortable kind of running up that scale to you're right, you would capture more tests. If it was just blanket, you'd almost get first lifetime, you'd almost get no refusals if you didn't cap it.
Because a judge could say, listen, this person blew 0.16. He was at a sports bar around the block from his house. He said, I shouldn't drive home, but I don't want to leave the car. You could create a set of facts where the judge could look at a mature person and say, you know what, he needs to, he's this 0.16 I'm going to treat differently than I might a 0.16 under another circumstance. So I think some things we should trust our judges.
And I think that goes back to the judge's point of let me hear everything, let me see a BAC, because I think in the best possible scenario, everybody would give a breath test with probable cause. Everybody would give a breath test. And then people could sit back, they're learned and see these cases and say, right, it's the guy who came home from the Gwinnett Braves game and blew an 0.87 versus some 20-year-old kid who blew a 0.32. No, you're not getting conditional discharge for that. But and then to your point, if you didn't cap it or capped it sort of higher, you'd tell the world, just go ahead and blow, because the word on the street is to refuse. I can get you an acquittal every single time on a refusal. Or very close, and I don't think that's. I don't think that's puffery or whatever. I think it's very difficult, and I started wondering about that years ago when there's multiple. In the circuits that I run in, there are many more acquittals on DUIs than there ever were before, and I think the word has sort of gotten out to just refuse everything and go to a jury trial. So.
Thank you. Sure, Mac. Why don't you
Just
come on
real
up
briefly,
there, Judge?
I'm Matthew Kroll. I'm the Solicitor General in Douglas County. Mr. McClurg, I appreciate your presentation, and I heard what you said. And I think, number one, it's very ringing what he said. This is a gentleman who says, I practice this on a daily basis, and if you have a refusal, he can get an acquittal. We have to understand that. That's first and foremost. But I think, in my opinion, as an official from a county of 133,000 people, 135,000 now, my responsibility as an elected official is to keep the people on the roadway safe. And I think at times when we talk about what we're doing here and what this body is doing, we don't need to lose sight of that. We understand we don't want to overstep our bounds. We don't want law enforcement to overstep their bounds, what's in the law and what they can do and cannot do. But it doesn't, I think we lose sight sometimes that we need to focus on not on the offender, but the liberty interest of the individual driving down the roadway that didn't drink and drive. Mr. McClurg, I appreciate what you said, but that person who made that decision, I don't know, maybe I drank one too many. That's not the decision that we want this person to make. We want that person to make that decision, I drank one too many. I don't want to get arrested for DUI. I don't want to kill someone. I'm not going to drive. That's the decision that we want these offenders to make. And that is why we have thousands upon thousands of pages of law to prohibit people in this state from doing. And we have pages on pages of DUI law to get people not to drive under the influence of alcohol. That's what this has to be about. It doesn't have to be about how are we going to treat the offender when they are arrested for DUI. Yes, we want them to get the help. Judge Lawrence, he knows we're on top of it in Douglas County, doing DUI court, accountability courts, trying to get people to change their behavior. But I have to have the tools in order to do it. But my goal as a solicitor of Douglas County is to protect the safe, honest motoring public on the roadways, not the DUI driver. I'm not going to reduce a DUI. You're not going to get reckless in Douglas County. You're going to trial unless there's a legal reason or a factual reason. I'm not doing it. You're going to go to trial because it's my duty to my constituents to keep them safe. And I just wanted to say that. Make sure we keep focus on what we need to do here.
Thanks, Matt.
I'll take questions.
I'm sure. Well, there is a question. Chairman Golden.
Yeah, thank you, Mr. Chairman. It's not really a question. It was really more toward Mr. McClure's comments, and I appreciate the Douglas County Solicitor's comments. And I appreciate Mr. McClure's coming up here and speaking his piece. And he comes from a particular world in our particular side, our adversarial system. And I'm glad that we have it. It's the very essence of the strength of our system. But I did notice, and I think it echoes the solicitor's comments from a minute ago, I did notice that there was an underlying, I think the underlying message of what I heard anyway was that, that the .08 or the .082 just isn't as big a deal as the higher, BAC, when in fact it's a very big deal. And I agree that we have to go ahead, and our job here, and I think where we stand from a bipartisan standpoint, is the fact that that .08 is something that we don't want to see, and we've expressed ourselves in the years past by virtue of having that, on the books. If there's a refusal, and I heard, I just got confirmation of the failure of our current system. If you get a refusal, it's very hard to make a conviction. That tells me something is broken. It tells us something is broken. And so the framework that I think the PAC has put forward, I'm giving the PAC credit for the handout and for the presentation.
We just put it together.
Well, and it's credit where credit is due, because I think it represents an excellent starting point of, you can call it reform. I think I would call it modernization, because it reflects the current reality. And the current reality is that we want law enforcement to have the tools that they need in order to keep the streets safe, because that is the public safety. We got the big three: public health, public safety, and public education, in whatever order you care to put them in. And that's the primary consideration. There are other considerations that are important. Individual liberties are extremely important. And we may have, a granular difference, an important one, but a granular one in terms of the blood draw issue. That's a separate subset of public safety. And that's an important one to strike a balance. My sense is that compromise can be achieved there. But what I just heard from a member of the defense bar to my colleagues is that the system has clearly failed. When you can't make a conviction on a refusal, and there's nowhere to go for law enforcement, to me that is an inherent loss in the public safety column. And that's why I think the work that you're doing here, Chairman Rice, is so important. That was proof positive to me that we're going on the right track. Thank you.
Thank you, Chairman Goley. Comment, Chuck?
Just one comment I do want to make on the proposal before us, and we didn't see this before today, but I want to caution the members to be very careful if we proceed with any changes to the implied consent statute. And I say that out of an experience now of living through two different versions of implied consent that have been struck down by the courts in this state over the years. And that when we finally settled that, and remember, implied consent is really informed consent. And if we start doing some of the things that we're discussing here, just as Representative Setzler pointed out, and we have to start changing the way we word that informed consent, we go into a now well-established body of law that I think we should be very careful about headed down that road. So.
Mr. Chairman?
Sure. Judge.
This is a point which I brought before this committee and maybe one or two other committees last year about the concept of deferred prosecution or diversion for first offender DUIs. Almost half the states now in the United States have some sort of program or allow their courts to do this without a specific set of guidelines, including Florida. Oregon was one of the first. I agree with Chairman Golick. A .08, that's serious. It's not just a DUI. It's a DUI. And somebody who's .08 is not safe to drive on the streets of the state. A .23 on an 18-year-old, which I've seen, that's not safe either, but they tell a different story. If I were going to propose first offender diversion or DUI or deferred prosecution, number one, I'd make it available to first offense only, and I would not limit the ability of the diversion just on the point count, the BAC. If they would be, and this is what all the other states are going to be doing, and some of them are, is you get that BAC, and by the way, if you have the availability of diversion, you're going to get better compliance with implied consent, because the word on the street will get out that, hey, look, of the vast majority of people that's first offense, you do have this ability to not lose your license and not have a terrible stigma that this DUI has on people's ability to earn a living and all that stuff. But the BAC, combined with a clinical evaluation, a really good clinical evaluation, can help the judge discern whether you're a likely reoffender or you're not. The BAC is the strongest indication of the likely reoffender, but it's not in and of itself the only measure. If you can get a clinical evaluation in the BAC, put the person in track 1 or track 2 and have differing treatment standards, program standards for each, on a diversion program, you can keep that offender as much as 3 years. One of the frustrating things I've had is first offender DUIs at the .23 that are raging alcoholics. We get them for 1 year. Can't do anything with them in 1 year. You cannot deal with somebody in 1 year who is got an alcohol problem like that. I can tell you from personal experience, it's the most frustrating thing in the world to have somebody go for an entire year and know that when they're gone that day, they're going to go out and drink and drive. First offense. I think that the idea of having this diversion program or a deferral program is a good idea. It needs to be thought out. Oregon has it. They started out with it and it had mixed results. And I'm not necessarily an advocate for interlock for every first offense DUI. I'm not necessarily. But what they did in about 2007 was add interlock for first offense DUIs that are on the diversion program, and then it started having an effect on the recidivism rate, which is what we're talking about here today. And that's the big deal. It's really predicting who is likely to reoffend and intervening in that likelihood to reduce that. That's what we're really all about here. It's been shown that the threat of punishment itself isn't working that well. And the threat of punishment for somebody who is an alcoholic and who has an alcohol addiction problem is way down on their list. It really is. It's way down on their list. They don't make, as I said earlier, that risk-benefit analysis. Because as I said, I was talking to one of the staff members the other day, the little man in the head says it's okay to drink, doesn't care whether you can drive next week. Doesn't care whether you have a license. All that little man in the head wants is the next drink. Now there's plenty of folks walking around today, including some in this room, I'll guarantee you, who walk around with that little man in the head. And they do just fine. Because they have learned how to say no to the little man. But you don't learn to say no to the little man in your head by having to go to DUI school and having to pay a $300 fine plus costs, and for having to be on probation, or for having an ignition interlock. All of those things may be part of learning how to say no to the little man, but they're not in and of themselves sufficient. So I think that's about my comment on that.
Thanks, Judge. I appreciate it. Regina, why don't you?
Thank you, Mr. Chairman. Gentlemen, in considering these notions about conditional discharge or pretrial diversion, or diversion, I should say, these things we're talking about, are there limitations on expungement of first DUI offenses?
There is, as of now, no. If it's on your record, it's on your record. It's not just, there is no such thing as expungement per se anymore. It is restricted access to criminal histories. There is no restricted access per se for DUI. Part of the problem, though, for those who are never going to reoffend the first offense, part of their problem is this. Even if you were to provide restricted access to their criminal histories, And it's a tiered approach. Law enforcement and judiciary are always going to get access to everything. Employers, not so much. But when you go in and apply for a job or a professional license, and the question is, have you ever been convicted of any crime? Whether they can get access to your record or not, you got one or two choices. Tell the truth and say, yeah, I'm convicted of a DUI, which may exclude you from certain benefits and opportunities, or lie. Why not give that first offender who is never likely to reoffend the ability to honestly say, no, I've never been convicted? Why not? I get anecdotal stories all the time. As late as last week, somebody had a DUI like 30 years ago and couldn't get a Georgia real estate license. I don't know if that's true or not. I asked for proof of it to bring today and didn't get it. But there's, particularly in the nursing profession, lots of professions. DUI is a big deal. And for the person who's not going to reoffend, and as a matter of fact never has reoffended, to keep them saddled with that for the rest of their life makes no sense. Now, I will say this, though. That's the carrot end of the stick. The stick end of the stick, if you will, that I propose, that I haven't seen in any of the other state statutes, is this. If you go through this diversion program, if you do everything right, and if you don't have a conviction, and you can go sign that form truthfully, but then you do reoffend, then I would propose that second offense, that if you do reoffend, your first diversion is then by law treated as a second, as a first conviction, not as a non-conviction, so that the second offense will be treated as a second offense, not a first.
If I could follow up just briefly, Mr. Chairman. Last meeting, there was some discussion, I believe it might have been the West Virginia model or something like that, but some mention was made that there may be some funding requirement by the federal government that would restrict how we might approach this first offense situation. Can anybody explain that to me?
I think it has to do primarily with multiple offenses. Under federal law, under MAP 21, there are requirements that for multiple offenders, certain things kick in. So the question is, if you never have that first offense, how do you get that second?
Yeah.
So that's what the judge, I think, was just pointing out. That
and the National Highway Traffic Safety Administration, they fund or submit money into the Governor's Office of Highway Safety. So a lot of these funds go for public safety across the state of Georgia.
And so there would be restrictions on those funds or strings attached to those funds?
Absolutely.
With regard to how we sentence?
There are restrictions placed on the money that's placed there. I don't know exactly how they dole it out, but the money is restricted to some extent.
I can kind of point that out. There are different funding sources that a highway safety office will receive from the federal government through the Department of Transportation, specifically the National Highway Traffic Safety Administration. And in there, depending on which category of funds we're talking about, there are requirements that if you are to receive these funds, in some cases at all, or you may receive a lesser amount unless your statutes reflect certain things that Congress has said have to be in your statutes. One of those has to deal with multiple offenders, because we all know that multiple offenders are, high on the chart of things that we want to stop. So with respect to multiple offenders, for example, the requirement of having an ignition interlock is on the books in Georgia to be compliant with the federal law requirements of those funds that we receive that are used through the Highway Safety Office for the programs that Judge Lawrence just discussed.
And that would be one reason I would say that if you've got that second offense, the first offense would be noted on your criminal history, your driver's history, as a deferred prosecution or a discharge. So it's there. It'd be restricted access, so your employer can't get it. The insurance company may not be able to get it. Judges and law enforcement can get it. Federal government can get it if they want. So that the second offense then brings that back up.
And Mr. Dallas, the interlock ignition device, although it's mandatory on second DUIs if it's for drugs, will it detect drugs?
No, they do not. It's alcohol.
So it's mandatory and it's not working for second DUIs with
Well, that was part of the earlier discussion as to, with respect to drugs. I mean, we have drug driving, and, you know, that is a big issue. There's no question. All of us at this table and many others are trying to grapple with the best way to interdict drug drivers, whether they're legal prescription drugs or illegal drugs. And there are a whole lot of programs in place trying to do that. I will say, based on my observation, that many drug drivers are also probably drinkers. Now, having said that, what we are finding, I think, in many instances, that you'll have a stop, and the person is obviously under the influence of something, but it's not alcohol. There's not a detection of alcohol through any devices. But in terms of the SFST you may try, or the drug recognition expert, of which the state doesn't have enough, but has a good number of well-qualified ones, can go through a process to assess whether or not this offender falls within the category of a drug driver. But the point you're making is, as to the IED, does it detect drugs itself? And the answer would be no, it does not.
So there's a piece of that mandatory sentencing that is not targeted toward that offender in serving any purpose in terms of their particular issue and problem.
Yes, if you had, I would absolutely agree. If you had, and perhaps Judge Lawrence with a lot more experience than I do specifically, if you had first conviction due to drug driving, second conviction due to drug driving, I think you'd be correct. If any one of those two included alcohol as well, then I would say, well, obviously the person's a drinker. And I'll have to say this, if it's a less safe case, for example, and there's not a detection device, in other words, we don't have the BAL, then we don't really know whether that impairment is due to one or the other, unless the officer, of course, smells alcohol, and then they can note that.
And right now, the judge has no discretion to determine or assess those circumstances. It's simply mandatory, the interlock ignition device.
Yes, now, and it is, but remember, the interlock device is obviously a great behavioral changing tool, but I don't know, Judge Lawrence probably has a lot more with this than I do.
Well, if an officer experiences on the roadside a person who appears to be impaired in some manner, and alcohol is ruled out, then the officer should go to the next step. They would hopefully, if available, they would get a DRE, a drug recognition expert, there to evaluate that particular individual to see whether or not he was showing signs of impairment based upon the procedure he would go through. And it's an elongated process that you have to go through, and you're trained on it, and it takes time to do. But if the officers do it and do it correctly, it can be used as evidence against the individual in court.
But a driver who is high as a kite even can blow into the interlock and drive anyway, right?
That's true, but he wouldn't get any response if they have not consumed any alcohol.
Right.
Thank you.
We got several people who want to comment on this. I'm going to move to Craig Foster for a second here.
Thank you, Mr. Chairman. I just wanted to, it's really a question for clarification, and if you will mind coming back up. No, I'm sorry, the gentleman, the proposal that we're discussing. And to you, Judge, I'm from Paulding County, and my father was a Superior Court judge, and we talk about these issues quite a bit. And one of the questions one of the things we were talking about recently is the DUI courts, or the accountability courts. And you mentioned the diversion program, and my question to him is, why have Paulding has grown? Why have we not gotten an accountability court to this point? And he said, well, our biggest issue is a lack of rehabilitative resources. If we were to do a program like this, and it applies statewide, could it be done equitably across all jurisdictions when you consider those counties that don't have access to rehabilitative services? They might have a DUI school, but that's the limit to what's available to the defendants in their jurisdictions.
Okay.
I think it could, and sort of what's ultimately going on is the person who wants this sort of treatment, I mean, they have to comply. And one thing to be clear, all I'm really saying is that I want this off their record. They're still going to get all the punishment and all the treatment. And so if you want this conditional discharge, while I understand different counties and different jurisdictions have different sort of resources, there's enough flexibility in conditional discharge where a local judge could say, you need to go one county over. If you want this treatment, you need to go one county over to get either their person who does drug and alcohol evaluations, or a judge could say, look, you need to go see a psychologist or psychiatrist, or you need to go to a 12-step program, or it would be almost just plenary power in a judge to determine, based on BAC and the other facts and circumstances, what he or she thinks is appropriate. And so it doesn't have to be a full-blown 3-year track. It could be to go to some AA meetings. It could be some additional urinalysis testing. It could be to go see a psychiatrist or psychologist in a local jurisdiction. It could be going one county over. So there's, yes, I do think equitably with letting a judge sort of field those things and know what his or her resources are to be able to get to what we're trying to get to, which is trying to determine what level of problem does this person have, and how do we, because when you read the conditional discharge statute, all it really says is, when it's talking about that issue, it says the judge can require the person to can require the person to undergo a comprehensive rehabilitation program, including, if necessary, medical treatment, not to exceed, you can put whatever number of years you want in there, designed to acquaint them with the ill effects of drug and alcohol abuse, and to provide them with the knowledge of the gains and benefits which can be achieved by being a good member of society. That's all a judge has to fashion his treatment program around, which is sort of broad, which gives the judge a lot of discretion. So yes, I think you could have jurisdiction by jurisdiction sort of different approaches. Some might be more robust than others, but I still think a judge could have the discretion and say that this person can do this. Now remember, he could get a .32 guy. Yeah, he could have a 3.2, and I'm just not allowing this. I don't care what's going on. I'm not going to allow this. But yes, I think it's all possible within the statute. So, and to the judge's point number 9, Your Honor, talks about the exact issue of, it says that this is intended that for recidivism and sentencing purposes, as well as driver's license ramifications, a DUI conviction after one entered under this proposed statute will be considered a second. So that sort of goes back, look, you're going to get this benefit. You're going to get this treatment. We're going to kind of rehabilitate you, and you asked for it, you got it. You get another one, and now we're going back to 2. Now we're talking ignition interlock, we're talking multiple penalties, and so on and so forth. So
we're going to have to move along, Chris, but I appreciate your answer to that.
Yes, sir.
Judge Lawrence, why don't you comment, and then we got one more back here, but yeah, you can come up to but Judge Lawrence wanted to comment.
It's all right with you. I have an appointment. I've got to get.
We are going to stop here in a moment. Okay, but.
Okay. Currently, we have 22 accountability court programs operating in the state of Georgia. We have over 12,000 participants who've gone through our programs in Georgia. We're close to 13,000 that have been through our programs. The accountability court programs are under strict judicial supervision of program participants. Each participant is exposed to the following items. First of all, individual accountability is huge. Eligibility for the participant is determined. We have frequent and random drug testing. We have a treatment regimen for each participant. We have individual and group counseling sessions, probation supervision by law enforcement officers who surveil our population of offenders. We have an expert in drug identification who's on our team. We have a drug court coordinator and a judicial official who is the judge. The Athens-Clarke County DUI drug court program is designated as a National Academy Court program, and we train other people from other states, other people who want to come into Athens and be trained on the NHTSA Academy Court program. And in fact, on the 21st day of this month of October, we will be training 5 more teams, one from Delaware, one from North Carolina, one from Virginia, one from somewhere out west, and one from Georgia.
Okay.
All of our training programs in Athens begin, and it's a 3.5-day intensive program for these people to be trained, and they leave the state. Now, that being said, our accountability courts are working. Research that we went through shows the validity and the positive outcomes that we've had during our 3-year research project that we underwent, which was Hall County, Athens, Clark County, and Chatham County, Savannah. We showed that we had a 9% recidivism rate over a 3-year period for our participants that continued in our program. We jumped to 24% in another population of offenders, and then we jumped to the highest group who were not the most compliant at a 36% because they had no training or treatment or things of that type nature. We have some issues, I'll be quiet, and we have worked very closely with the Department of Driver Services. I feel sure that they're putting the ignition interlocks on as we do. We put ignition interlocks on all the participants that come through our program.
Okay.
And so they stay on for the 12-month period.
Okay.
Our minimum period of time that a person's in our program is 12 months. Then it can go up to 24 months, or 30 months, or 36 months, depending on what particular point they have reached in the program. So we think that we're doing it right. We're doing a good job with it, and we're having a lot of success. My good friend Judge Anderson and I don't necessarily, even though we're friends, we don't see the same thing. I'm not a diversion person. I'm a DUI. I believe the DUI should be treated as a DUI, and it should be processed in the same manner, whether it's plea of guilty or plea of not guilty, and they have a right to go to trial. And that's pretty much, I think, the attitude of our 22 programs that are operating across the state of Georgia. But again, I'm not a proponent of pretrial diversion. I'm just not satisfied with that. We also have a number of rural areas that we do not have sufficient treatment needs for that population of offenders, and that's an issue. And I'm being upfront about that. We have a distance for some of our offenders can't get 40 or 50 miles away to be able to get ignition interlock installed on their vehicles. And that's a continuing problem. It's something I'm trying to address. I'm having to kind of herd sheep over 22 programs in the state.
So the point of your message here is that your program is working.
Yes, sir.
It's not resourced to the level it should be.
It's working, and it will continue to grow simply because the outcomes that we have seen since 2001, we had our first program, which was in Athens, Clark County, has now grown to 22 programs, and we perceive that they will continue to grow in number because of the success we've had in the
Well,
state.
we congratulate you on that. I don't think Gwinnett County has a part of those programs, and they continually do well with it, from what I understand. I thank you for your comments on that, Judge. I don't know your name, so if you'll just state your name.
Cynthia Zimmerman. I'm with the Department of Driver Services,
Right.
and I just wanted to comment in reply to an earlier question. The Federal Motor Carrier Safety Association requires that a DUI offense committed in a commercial vehicle carry a disqualification.
Right.
What you may not realize is that they also require that an offense in any vehicle committed by a commercial license holder also carry that same penalty. Right. So the conviction would have to be there.
Yeah, we understand that.
Okay.
On the commercial, I don't think we're addressing that side of it, from our perspective.
Well, it will just require that those convictions come in following a different path somehow.
Yeah.
Okay.
Yep. No, I think, no.
You're seeing V.
Nothing wrong with that. I'm exhausted. Too much information. Yes, why don't you ask the last question?
All right. Let me ask you guys a question.
Yes, sir. I'm sorry.
I mean, I hear the concern about a mistake that is never recommitted again, a first offense DUI. that follows somebody forever. And I understand that you either have the choice of lying or telling the truth on an application. And but could you not, without doing some kind of complicated diversionary statute, just tweak the existing statute? I've got the right on a first offense DUI to plead NOLO right now. Could you not just restrict access to a first offense NOLO conviction and accomplish the same thing? It doesn't count as a conviction because I'm not admitting guilt. And if you restricted access, the employer can't see it anyway. And so the one mistake you could address that way without doing a diversionary statute.
Sure,
Am I missing something?
No, we entertain a number of NOLO contender.
But if you restricted access to that, would you not accomplish the same thing without having to go in and set up a straight, a separate diversionary program, et cetera?
You're just talking about going to the restriction statute and add a
Right.
first offense DUI that is sentenced pursuant to NOLO.
Right.
Yeah.
I mean, from a procedural standpoint, that's probably one of the simpler ways to do it, yes.
Okay. That was my question.
Employers are smart enough now, they'll say, have you ever pled guilty or NOLO contendery to? So you're not eliminating that.
Well, the question is, have you been convicted? And a plea of NOLO contendery is not a conviction.
Say, have you ever been convicted of, pled guilty to, or pled NOLO contendery?
But they could ask the same thing and say, have you ever been charged with if you did it for diversionary? So, I mean,
Yeah, I know.
but anyway.
But there is a distinction between a conditional discharge and a NOLO, because a NOLO is going to be sentenced.
Okay.
That's how you get to the plea, but you would still be sentenced. So there is a distinction between that. And
Well, I understand that, but it's still not a conviction.
Yes, sir, it is a conviction. A NOLO plea leads to a conviction. It is a conviction.
Well, I mean, it leads to
It's
a...
just not an admission of guilt
Right, okay.
necessarily.
But does it not say that it's not a conviction?
No, it is a conviction.
It is a conviction?
So that's why there's a distinction between a NOLO plea and sentence and a conditional discharge.
In the general criminal NOLO plea is not a conviction. A DUI NOLO plea is treated as a conviction. That's the distinction.
Treated as.
Treated as a conviction, yeah.
Okay.
But if you plead NOLO contendery to running a stop sign, that's not a conviction. Or NOLO contendery to burglary, that's not a conviction.
Okay.
Let me echo Judge Lawrence. I am one of the biggest advocates for the diversion courts, not diversion, but accountability courts you can imagine. They're great. We need more resources for his courts, but we devote no resources to the first convictions, and that's all I'm talking about. Okay. I really do have to run. Is that all right with you?
I'm sure everybody else does too here, Judge. I mean, we said that this would be a 1 o'clock close time today. Look, we hardly even got to even talk about costs and, the effect from a financial standpoint and the burdens on the people who are involved in this. And I want to spend some time on that. The committee wants to spend some time on that because that came up as one of our issues, particularly if you're talking about the interlock situation, how that's all handled with indigents and this type of thing. So we're going to get that. We're going to get to that next time. But I think I can speak on behalf of what remains of the committee here. That we really do appreciate all the work you're doing. We really want to make sure this fits together, because I do think that the intention is to legislate this again with the support of public safety and the governor's office in terms of doing something about enhancing our way of managing the DUI statute. And with that, are there any closing comments from the members of the committee?
I appreciate your presentation. I think it was very helpful.
Yeah, this is good. It's good. Guys, thanks an awful lot. We really appreciate all of you being here today. We'll let you know about where we go from here.
Thank you.
you.